Let us pause for a while and put ourselves in the presence of God. Let us pray. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. We pray, Almighty God, that you bless us, that you bless this organizational meeting with good engagement and deliberation as we begin our legislative work for the 20th Congress. Help us to be useful to the community, our nation, by becoming true servants to the people. Inspire us to realize and achieve our solemn duty as legislators to bring prosperity and peace for our beloved nation. Lastly, continue to remind us that all that we do today and all that we accomplished is for the pursuit of truth, fairness, love, and ultimately for your greater glory. We ask this in your holy name. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Let's be seated.
Ang magandang hapon po sa ating lahat. My dear distinguished guests, distinguished colleagues, our esteemed resource persons, secretariat, guests, ladies and gentlemen. Welcome to the final meeting concerning the establishment of an independent commission against infrastructure corruption, as delineated in House Bill numbers 4453 and 5699. The primary objective of these proposals is to investigate corruption and irregularities in government flood control and related infrastructure levels. The meeting is called to order. In recent months, alarming revelations have dominated the headlines, inciting outrage across the nation regarding the egregious mismanagement and misappropriation of public funds allocated for flood control initiatives perpetrated by scrupulous elements within the Department of Public Works and Highways Office in Bulacan in collusion with corrupt contractors. To rectify these malfeasance, President Ferdinand Marcos Jr. issued Executive Order 94, which established the Independent Commission Infrastructure to investigate corruption, determine accountability, gather evidence, restore public trust, and promote transparency. House Bills 4453 and 5699 have been introduced to institutionalize the Independent Commission against Infrastructure Corruption, endowed with investigative and coercive powers to apprehend corrupt individuals and invoke the full force of law to ensure justice is served. The Committee on Government Reorganization created a technical working group to harmonize House Bill numbers 4453 and 5699 and to come up with a consolidated version as a matter of course. In today's meeting, Chairman Leila is ready to report on the results of the task of the technical working group. But before the technical working group report of Vice Chairman Amante, let me acknowledge first with our colleagues and later Commissioner Leila will acknowledge the resource persons who are present in today's meeting. We acknowledge the presence of Congressman Honorable Leila de Lima. Thank you. Representative Katab Mag-Araw District of Dumagat Island. Representative Honorable Charlene Banyas Cabrales, District of City of General Santos. We'll read the Honorable Simanuel Tadio Child Ayokno, Bayan. Representative Edgar Eloy, Second District of City of Calaucan. And our Vice Chairman, Loreto Samante, Third District of Laguna. Also, we'd like to acknowledge the presence of one of our authors, Congressman Toby. Thank you for coming. With the members present today, I declare that there is a quorum. We are now 23 elected members of the government organization. Section 7 of House Rules, 1/5 of all the members shall constitute a quorum. And I direct our concept to acknowledge the resource persons, please. Concept, right?
Thank you, Mr. Chairman, and good afternoon to all the members of this honorable committee. I am pleased to acknowledge the presence of the following resource persons and their agencies. To start with, Attorney Brian Hasaka, the Executive Director of the Independent Commission for Infrastructure, or the ICI. From the Ombudsman, we have Attorney Chairman Rafaman, Assistant Ombudsman, Office of Legal Affairs. From the DPM, we have Attorney Tricia Baraan, the Director for Budget Information Legislative Service. From the Anti-Money Laundering Council, we have Attorney Romel Tiho, Deputy Director, Litigation and Evaluation Group, Investigation and Enforcement Department. And from the Bureau of Internal Revenue, we have Attorney Ryan Burke, John Neal Tibayan. And from the Department of Public Works and Highways, we have Attorney Maximilian Anthony Fernandez, Attorney Alvin Daniel, and their staff, Ms. Elisa Hortaleza, Joanne Mamig, Mira de Alfanta. And from the Civil Service Commission, we are honored to have Director Attorney Alma Poranda. From the Government Procurement Policy Board, Technical Support Office, we have Mr. J. Mar Bahrain, the Procurement Management Officer 4. And from the Securities and Exchange Commission, we have Assistant Director R.G. Lacanaya. And from the Civil Contractors Accreditation Board, we have Engineer Sergio Rotomi, Acting Executive Director. From the commission, from the UP Law Center Institute of Government and Law Reform, we have Attorney Kathy Alcantara. And I think we have no less than the chairman of the committee who will be present in this committee meeting. And of course, we also have the presence of the technical staff, the Congress members, and the resource persons. That's all.
Mr. Clay, how about DOJ? I don't see a representative from the DOJ. And has DOJ been ever represented in the various hearings? And I also didn't see any representative yesterday at the technical working group.
In
The
the briefing we have on bias.
But after that, none. And they have not submitted their position paper as well. Unfortunate, because there are also legal issues. But anyway, they are considered to have waived submission of their position paper. Thank you.
Thank you. We now call Technical Working Group Chairman Amante to present the Technical Working Group report.
Yes, good afternoon, Chairman Salvador PLEYTO and esteemed members of the Committee on Government Reorganization, distinguished authors of the ICAIC bills, esteemed resource persons, Secretariat, ladies and gentlemen. As the Chairman of Technical Working Group, assigned to harmonize the two legislative measures, House Bills number 4453 and 5699, as well as to consolidate and draft a substitute bill, I am now pleased to present the TWG report from our meeting held yesterday, November 12, 2025. Our guidance of the TWG is consolidating the two measures, some parameters relevant to the mandate of the Committee on Governmental Organizations, particularly on its creations and functions. There are primordial concerns or parameters the TWG has adopted. Number one, necessity of the reorganization. Number two, constitutionality of the bill. Number 3, redundancy or duplication of functions. Number 4, purpose or main objective of the bill. Number 5, organizational structure. Number 6, logistics and budgetary requirements. And number 7, administrative feasibility in realizing the main objective. There was a productive engagement among the authors and resource persons regarding the provisions of the draft substitute bill on House Bill number 4453 and 5699, which was meticulously prepared by the Secretariat and served as a working draft. There were substantive refinement of the substitute bill such as number 1, include in the declaration of policy of the SB statement to justify the power of the envisioned ICAIC to issue whole departure order and watch list order. Number 2, review the composition of the commission, ICAIC, particularly the qualification standards of the commissioners. Number 3, clarify the power to demand and open access to information relevant to the exercise of the functions of the ICAIC. Number 4, add provision to define the provision on the witness protection program on the determination to qualify as a state witness. Number 5, put a limiting provision on the power of the side person in contempt by the ICAIC. Number 6, clarified some functions of the commissions ICAIC to rule out redundancy or duplication of the ICAIC with existing agencies. Number 7, added CAAP, Marina, and LRA, ROD, or Register of Deeds as support agencies to the ICAIC. Number 8, clarify the designation or deployment of investigating personnel, lawyers, etc., or relevant agencies to the ICAIC. And number 9, clarify the budgetary requirements of the ICAIC BBM. Number 10, conduct an executive session by the ICAIC. And finally, the PWD proposes the title of the unnumbered substitute bill as an act creating the Independent Commission Against Infrastructure Corruption, defining its mandate, powers, and functions, and appropriating funds therefore. The task of the technical working group is now considered terminated with the submission of the PWG report and the unnumbered substitute bill, accompanied by the proposed title for the consideration and deliberation of the Committee of Governmental Organization. In conclusion, I extend my heartfelt gratitude to Chairman Salvador PLEYTO and the esteemed members of the Committee on Government Organizations for their trust and confidence in appointing me as the Chairman of the Technical Working Group of the ICAIC bills.
Thank you, Vice Chairman for the Technical Working Group report and for crafting subject bill for discussion in today's meeting. I understand that the members of this committee, including the ex-officio members and the resource persons, will give a copy of the subject bill to email. But we will proceed, and I would just like to
Ipo-project natin. Discuss.
to ask,
Ayan na po.
I will start today. Before we do that, about the concern of Honorable Lima, the attendance of DOJ, that's why I instructed the Secretary to prepare a highly worded letter for them because they were in technical briefing. They were present.
Via Zoom.
Have they submitted any comment?
POG.
Susulatan natin lang. Thank you po. Do you have comments or announcement on the provisions of the substitute bill consideration of the committee? Let us discuss the provisions of substitute bill line by line. Last will be the probably title. Amendments to be considered by the committee is through a duly amended motion. Can you ask, can you hear me? Any other voice?
Mr. Chair,
Honorable Lima.
can the entire section 2 please be shown? Because I think section 1, there is no proposed amendment. I move to amend section 2 by deleting altogether the last paragraph. I actually this almost the entire section 2 has now currently worded, came from my office, except for the first paragraph. We added the second and the third and the last paragraph. But upon closer and deeper scrutiny or reading, I thought that it would not really be necessary to include the last paragraph, which reads, wala po kasi akong copy, so I'll just read from the screen. Further, to effectively carry out the mandate of the investigative body and consistent with Article 3, Section 6 of the 1987 Constitution, the curtailment of the right to travel.
That's the last page, bro. That's the last page.
So the next page. So that's that covers lines 1 to 8 of the second page. Further, to effectively carry out the mandate of the investigative body and consistent with Article 3, Section 6 of the 1987 Constitution, the curtailment of the right to travel may be curtailed by reason of national security pursuant to the provisions of this Act. Maliw at ang pagkakasulat ng aming proposed can I have it?
Sa huli muli.
Where's Jesse?
Lahat na tayo meron po sa akin guys.
Can I have it? Ano na? Conversion natin. Mali pa pang kopya nila. Pinag-usapan ko kasi natin po ito kahapon during the TWG, and I pointed out that in order to really be clear about the grant of the power to issue home departure order, kasi yan po ang bagong power na binibigay natin sa komisyon. The power to issue HDO. Dahil alam naman po natin na sa Constitution, hindi basta-basta pwede nare-restrict ang right to travel. Pero actually pwede kapag ma-justify na pasok siya dun sa tatlong instances na nakasabi sa Constitution. At ito po ay national security, public health, and public safety. Now, so in-explain ko po kahapon sa discussion natin na basta ba nailagay natin sa Declaration of Policy something there which really talks about national security. Na ito pong usapin ng malawakang pandarabong, corruption, plunder of public funds sa mga infrastructure projects na ito really impacts on the national security. And that's why yung ating consensus po kahapon ay ipasok dito sa Declaration of Policy. Now, kaya nga po, you will see from the second paragraph of Section 2, the state recognizes the systemic corruption in infrastructure projects, particularly those involving flood control, poses a fundamental threat to national security as it undermines the stability of nations by eroding democratic institutions, weakening state capacity, and fueling social grievances that can escalate into conflict and insecurity. Further, corruption diverts public resources intended for development and disaster prevention, diminishes citizens' trust in government, and enables organized crime and other forms of violence to flourish under compromised systems of law and enforcement. And then ang susunod pong paragraph, to this end, it is a need for an independent and dedicated body designed to investigate with experience allegations, complaints, and issues on grafts and corruption related to infrastructure projects, and recommend the filing of necessary criminal, civil, and administrative actions against erring individuals. Mr. Chair, colleagues, distinguished members of this committee, I think we can stop there. And we need not include any more the last paragraph. It specifically pertains to the curtailment of the right to travel, because otherwise it would give the impression that the whole bill will only refer to the curtailment of the right to travel when it's not really the intention of the bill. Mas malawak, mas comprehensive itong bill na ito. So I hope the other members and Mr. Chair will agree to that proposal.
Mr. Chair, it was already deleted in the. It was already deleted because we had already agreed to delete it. Ma'am, it's already deleted. It was already deleted in the draft.
Yes, the first three lines, hindi po na-delete. So, pwede po i-delete din po. Nagkamali lang po ako. So, thank you.
It was just to clarify that Congresswoman De Lima wanted the whole paragraph. The whole paragraph, yeah. It was just to state that.
Yes, sir. Yes, sir. Thank you.
Before we put that in motion, can I ask Mark from resource persons?
Thank you, Mr. Chair. Thank you, Honors. I think Congressman De Lima was correct in that was what was discussed yesterday. But if I may, Your Honors, the matter does not only pose a serious threat to national security, so can we add also threat to national security and economy? Sir.
So may I respectfully move to insert the word on the second paragraph, line 11, security and national economy. Is that correct? National economy. To insert the phrase national economy after the word security on line 11 at page 1. I so move.
The amendment as suggested by Director Saka. Line 11.
Yes, sir.
Any other remarks or comments from the other resource persons? Kung wala na pong comment, we're gonna ask the motion. Kung approval.
Mr. Chair,
Mr. Chair, may itatanong lang po ako. Just ask. Before we approve the entire section 1. Section
Okay, sige, go ahead. Okay, after you na lang po.
I'll just later oppose my query on the appropriate section. I thought kasi you'll approve everything. Okay, see you later.
Okay.
Mr. Chair, wala na on section 3.
Section 3 na po.
Second thing,
Oh.
Okay. Mr. Chair, just a clarification with respect to section 3. Okay, because it says here that the independent body is tasked to investigate anomalies in all government infrastructure projects. So clarification ko lang po, when we say infrastructure projects, there are those implemented by the national government with funds coming from the coffers of the national government. And there are also infrastructure projects that are being implemented by the respective local government, from which the fund is coming from the coffers of the local government. So will this independent body include all anomalous infrastructure projects that are being implemented by the local government? All clarification po. Yes, because especially there are also big ticket projects are being implemented in the local government. Hindi lang naman ang na-implement ng national project like DPWH or other agencies in the national level ang medyo problematic. There are also anomalies in the local government, projects that are being implemented through the local government with funds coming from the coffers of the local government.
can we actually value to respond to
Mr. Chair, meron mo po mga agencies like the Ombudsman who can perform this task. Kasi po, this is a special commission born out of the infrastructure mess committed by the national government agencies. So imagine there are 1,600 LGUs. 1,600 LGUs. Meron pa po dyan, may infrastructure din ng barangay. 42,000 ng barangay. So I don't think that the independent commission can cope up with the task of investigating all this. Kasi po, moto-proprio sila. Ibig sabihin, pag may imagine it, the 1,600 local governments, 42,000 barangays, ay pupunta rin sa kanila at magbibigay ng mga information, then hindi po nila matatapos yung trabaho nila. Sabi nga ni Attorney Brian, nasa kakahapon, 235,000 projects yung naroon po sa kanilang agenda. Nililimit na nga lang po nila into around 35,000. So I don't think that they will have the capability to investigate locally implemented infrastructure project. So para po hindi naman maabala yung kanilang trabaho. So, ito naman po yung this was brought about by the ghost projects committed by the national government agency. So, kaya po, we should limit the scope to national.
We understand the national funds lang, national funded projects lang ba kumigay?
Thank you, Mr. Chair. Kasi mas maigi na klaro po sa simula kung asan yung coverage nito. Because there are also projects that are locally implemented that are quite outstandingly blatant yung anomalies. So thank you po for the clarification.
Mr. Chair, another amendment.
I've been thinking it all night kasi po 2 years lang po binibigyan natin sa kanilang term. And so, tingin ko po kulang yung panahon na yun. Ngayon po, kung mag-extend pa tayo, it will need another legislative action. And sa 2028 po, magkakaroon tayo ng national elections, so we'll have new administration. At kung hindi pa tapos yung trabaho nila, baka yung platform ng new administration would not want to continue with this. Sayang naman po yung trabaho. So I would like to propose that instead of 2 years, we extend the term to 5 years.
So that kung maaprobahan po natin to 2026, at least kung 5 years up to 2030, ma-encompass na po yung at least 2 years of the new term of a new administration. Thank you.
Thank you. Any comment from the amendment to our
Comments?
Honorable Lima, please?
The very reason why we limited it to 2 years is to highlight the very urgency of completing the task of the commission, although we realize that dahil nga sa lawak at sa dami at sa lalim ng mga corruption na ito, baka nga kulang yung 2 years, and that is why we have that qualifying phrase unless extended by law. So I understand the logic behind the proposed amendment of making it 5 years, but extending it but making it 5 years, baka naman masyado na rin ano yan. Siguro ang mas magandang alternative would be, why don't we just say that the term will be up to 2028? The term is up to 2028 and subject to extension by law. 2028 will be 3 years.
Oh, that's only 2 years. Kasi ang approval niya mga next year na. Hindi naman natin ma-approve yung December lahat yan. Siguro. So by next.
So it's a question of which one is a reasonable date.
3 years.
2 years is rather short. 5 years may be long.
3.
And it should go beyond 2028.
3.
I think our target really is to pass it before the Christmas break, no? And I think even the Senate's target is to pass it before the Christmas break, no? So I'm very hopeful na the BICAM will be done before the Christmas break. Hence, we will be able to pass it before the year end. I think that is the target of both the House and the Senate, no? So, siguro maganda, we put a specific date. No, I mean, I'm okay with Congresswoman De Lima's proposal to put a specific date, like let's just decide kung anong date in 2028.
Okay.
Yeah.
Mr. Chair, kung masyado mahaba sa tingin yung 5 years, I would settle for until December 31 of 2028. Okay with you? Para yung fiscal year, wala na silang budget.
Okay.
Okay with you?
Yes. Unless extended by law. Meron pa rin lagi yung ganon. Kasi baka kapos pa rin until December 31,
2028.
2028.
Okay. Chairman, can Congressman Elise present it in a motion so that we can?
Yeah, the motion.
Line 2 of
Section 3.
or Section 3. Line 2 of Section 3. The commission shall exist until December 31 from the date of its
from the activity of this
yeah, but no, I don't think we have to mention anymore the date of the effectivity of the because we're already the commission shall exist until December 31, 2028, unless extended by law. That's the amendment.
Any motion?
Mr. Chair, may I interpose an objection? And perhaps propose another amendment. The concern I have is that if the commission, just hypothetical situation, let's just say that the new whitewashing the results of the independent commission's investigation, it may exercise or exert its power during the time that it is there after when the new administration assumes office. So I would suggest that we give the committee its lifetime until June 30, perhaps, 2028.
So, Mr. Chair, is my understanding that the proposal of Congressman Diokno is up to the term of the president. So as soon as the term ends, that the body will also expire. Yes, I don't have any objection against that, Mr. Chair.
Mr. Chair, ang ibig ko sabihin natin, we will cast doubt to the next administration while not casting doubt in the present administration. Second, hindi naman ibig sabihin yung 2 years or the 2 years or 3 years na matatapos nila lahat yan eh. It's still within the priority of the commission. Kung ano yung matatapos nila. Hindi naman ibig sabihin nila, hindi yan yung mga pinaka-importante, it's up to the commission to determine and to finish. Di ba? So, ano po yun, masyadong subjective kung ang reason natin, we are casting doubt to new administration. Diba? Yun ang parang,
May I respond, Mr. Chair? Hindi na po ako nagka-cast doubt. I'm just looking out at the possibilities, and I phrased the situation hypothetically. So I'm not saying that it will happen, but we want to be sure, since we're crafting a law, that it will cover all possible situations.
Chair, baski po yung administration na ito, kung ayaw nila resulta, they can also exert efforts to undermine or to influence the results of the investigation. It's up, really. We have to trust the commission. We have to trust the commission because we created it.
Mr. Chair,
Ang
I would like to move we retain the section. Because anyway, as you were discussing po kanina, nakalagay naman po dito unless extended by law. So, even before the end of the 2 years, if there is the necessity to extend it, you can always extend. So, yung reason po kanina why there was a discussion on extending it ay maybe too short. Pero pupunta na rin tayo sa possibilities and situations before and after. Pero pwede rin naman po na after 2 years, so even before the end of the 2 years, ay may discussion na rin whether to extend kung talagang may pangangailangan i-extend yung term ng commission dahil hindi pa po tapos yung na-set niya.
Chair, I'll just respond. Ngayon po, yung 2 years, kung umpisa natin ng January, matapos yan yung 2 years, December 31, 2027. Hintaan niya na po yan, almost close to the campaign. Kung hindi tapos yung trabaho nila, kailangan natin magpasa ng isa pang batas. And during the heat of the campaign, mas mahirap po magpasa ng mga ganitong batas. Labanan na yan ng mga partido, labanan ng mga politiko, tapos magpapasa ka ng investigating independent commission, baka hindi na maging independent yan. We have the luxury of, dahil nakikita natin, may traction ang gobyerno because of the people's clamor for justice. Why not maximize? Maximize na po natin ngayon.
Mr. Chair. As of now, there seems to be 3 proposals, no? One is to maintain the 2 years, which will technically end, let's say, on December 31, 2027, no? The second proposal was to make it up to June 30, 2028, no? So, ibig sabihin, 1 year yung pagitan yan. 6 months. 6 months. So, parang yung pangatlo is 3 years, di ba?
December 31.
December 31. So, ibig sabihin, yung pagitan ng tatlo is 6 months. So, can't we reach a proposal na
middle ground. So hindi po sa 2 years, hindi rin po sa 3 years, iset na natin sa June 30, 2028. Kasi may proposal na 2 years, may proposal na 3 years. So iset na natin para middle ground. It's neither here nor there, parang compromise. Kung papayag po kayo. Kung papayag po kayo na June 30, 2028. So yung compromise between the 2 years and the 3 years.
Suspended for 1 minute.
Yes.
Meeting is through.
Mr. Chair, I respectfully withdraw my objection and the grounds I raised earlier. And I do support the motion of Congressman Elise to make the existence of the commission until December 31, 2028. Tama po ba akong yes?
Yes, I reiterate my earlier motion that we amend section 3, line 15. It will read, the commission shall exist until December 31, 2028. Unless extended by law. And yung section yun.
And then accordingly,
And accordingly, section 4,
line 38,
line 38,
page 2. Also page 2.
also page 2,
With the term of line 38. 38.
28. Dali, hindi ko makita. Yes, go ahead. Members of the commission shall be appointed by the President of the Philippines with a term up to December 31, 2028.
What's it?
Yes. No more reappointment, madam. No more reappointment. So we will end at, the sentence will end at, with a term until December 31, 2028. Yes, period. So move, Mr. Chair. Second.
It doesn't move and so then that the amendment proposed by Congressman Elise should be approved. Congressman Elise subject to style. Thank you, Congressman Toby. Section 1 to section
Section 3 and section 4B.
section 4B.
Section 3 and section 4. Yeah, I mean, yun na po yun. Yun na po
Yeah,
amendment.
yes, amendment. We now go to section 5.
You still have further amendments in section 4.
Because Lima, please.
I move to amend section 4, subparagraph A, line 24. So subparagraph 2. A licensed engineer or architect. Move to delete the word licensed. Engineer or architect. Because I am told, I understand that when you talk about engineer, not all kinds of engineers require license. Yes, a civil engineer requires license, but there are other fields of engineering that do not require license. What is, like, for example, industrial management engineer also, I understand, does not require license from the Professional Regulatory Commission. Ang importante po dito ay yung experience and track record. So I so move to delete the word license from line 24, page 2.
Kasi yun,
Mr. Chair, it's a clarification. Ang intindi ko po kasi yung industrial engineering course and management engineering course, though there is a term, because I entered in Ateneo as a management engineer in under management engineering course, no, though I did not finish because it was too difficult. Ang intindi ko po doon, it's not really an engineering course per se. Even yung industrial engineering po is not an engineering course per se. It's something, yun ang intindi ko. Yun ang intindi ko. Pero yung management engineering, I'm sure, it's not an engineering course because I entered that course. Yung industrial engineering, I don't think it's an engineering course. Is it an engineering course?
Yes.
Okay, so my mistake. Okay, sige, agree. Okay, thank you.
yeah, that's you remove on seconded that section 4, line 24,
Number 2.
number 2, delete the word license.
Mr. Chair, I just noticed in the notes on the board that the word civil is still present. Deleted na po yata yan sa PWG.
Any comment?
Mr. Chair, sorry po. Medyo bothered lang ko kasi we removed the word civil engineer. So it could be just any engineering field. And we're talking here of infrastructure projects.
Mr. Chair, dito po, yung tinanong ko po si ChatGPT, what is industrial engineering? Industrial engineering is a field of engineering focused on designing, improvement, or optimizing systems. So it's optimizing systems involving people, machines, materials, information, and processes. So it's an engineering process, not the hindi pareho mechanical, civil, na yung building ang dinedesign nila. No? So ito po yung ibig ko sabihin na strictly it's engineering the process. Kung baga paano mas maayos ang proseso. So hindi po kaya mas maganda kung pwedeng i-appeal na maging licensed engineer po.
May aeronautical engineer din.
Hindi, yun lang po. Kasi kung infrastructure, di ba po dapat talaga civil engineer. So I would want to appeal if the colleagues will agree na gawin na nating licensed engineer. Kung papayag lang naman po. Because yun na nga eh. Kasi yun ang intindi ko eh. So it's to engineer the process to make it more efficient, productive, safe, and cost-effective. Yun po yung industrial engineer.
Well, there's so much technicality about these things. So the point here is to give a certain leeway, and certainly it's the level of expertise will just have to be weighed with respect to the experience and the track record of a particular individual who has significant level of exposure in all of this infrastructure.
But anyway, Mr. Chair, I don't think, okay, Mr. Chair,
Okay, Congressman Tobias.
Mr. Chair, I don't think it's something that we should argue about because may transitory provision eh. Di ba? So, ibig sabihin, si Secretary Simpson naman talaga ang magiging role ng engineer eh. kung siya yung holdover capacity at sinabi natin yung term na matatapos kasabay, so it doesn't really, kasi pasok naman siya doon sa engineer. So okay lang sa akin.
Thank you.
Hindi naman licensed civil engineer o kahit di civil engineer yung member of the commission, they will be going civil engineers and architects. Okay, of course, to assist them.
Can we ask Director Osaka, any comment?
I defer to the commission, to the committee with regard to that. Because it's an inquiry, Mr. Chair. I agree. If that is the pleasure of the body, I have no objections, Mr. Chair.
Okay, thank you. Any further comments in section 2? There will comment from Public Works, Director Fernandez. Good afternoon.
I think, Mr. Chair, it would better that we delete the word license because one of the most competent person to be member of this commission is former Secretary Babe Simpson. He knows the intramurals and the ins and outs of infrastructure projects.
Sige po. Agree. Just,
Fernandez is Director for Legal when I was in Public Works. He was my acting director for Legal.
He's a builder industrial engineer.
Okay.
Okay, agree, Mr. Chair.
Okay. We move on to section 6, section 5.
Wala na po.
Power source.
Wala na po ba silang tanong sa section 9?
Wala namang tanong sa
Section 4.
section 4.
Mr. Chair, please with respect to section 4A number 5, I have a motion. This pertains to the representative from the reputable non-government organization, which has the primary purpose and expertise on disaster risk and management. My proposed amendment is as follows, Mr. Chair, that I move that we amend that particular subsection as follows. A representative from a reputable non-governmental organization, the primary purpose and/or expertise of which is in good governance, anti-corruption, public financial management, public procurement, and open contracting, or citizen monitoring of infrastructure projects. And we can also add on disaster risk and management, just to give more leeway to the appointing authority to choose the qualified representative.
Dalawa kanyang experience here. It has been seconded that section 4, line 33, number 5 of the
To be amended.
motion amendment of Congressman Jokno.
Yes. Ipasabit po po.
Can you submit Congressman Jokno to the committee? Thank you po. Let's move on to
Anymore.
Director sa akin.
Yes, Mr. Chair, just a clarification on section 4C. It says that the as far as line 41 to 48, I think this is with regard to the nominations. Yes, nominations to the commission. Is it correct is it a correct understanding that as far as the chairperson is concerned, the nominee will come from the IDP? With regard to the engineer, it will come from the ICE, and with regard to the accountants, it will come from the PICBA. Because it doesn't distinguish po. So, just a point of clarification on whether or not the shortlist will be coming from them as an entire body, or will this be individually per member of the commission? Will they form a group, or will they recommend respectively? Like, for example, yung IBP, sila ba po ang mag-recommend ng justice? Si PICPA, siya po ang mag-recommend ng accountant. Tapos si PAISE, siya mag-recommend hindi na nga civil engineer, ng engineer. Or gagawa po sila ng grupo, na 5 sila, at sila ang mag-recommend sa lahat. Oo.
Tobias, comment on the author?
Hindi po akong, baka it's a TWG, is it a TWG proposal, Mr. Chair? Or was it's not in my bill.
It's not in House Bill 4453. So where did it come from?
Sino po ang nag-recommend yan, Mr. Chair? Okay. Si Senator Marcoleta pala nasa si Congressman Paolo Marcoleta po ang nag-recommend nito. Kaya lang hindi po maliwanag kung collectively they will recommend or individually sa hanay nila. So I think we will clarify. At kung individually, mawawala po dito yung architect, yung UAP. Saka yung civil engineer, kasi ang i-recommend kunyari is industrial engineer. And sino mag-recommend ng academe tsaka ng NGO? Yung NGO meron. Yung academe, wala.
Kapalit na mainit.
Move to suspend first. Move to suspend. Move to suspend.
Committee suspended.
Mr. Chair,
Any comment on the matter of section S11?
I move that we delete lines 41 up to 46 of section 4C, but retain the last sentence, which reads as follows. Each member shall be of good moral character, of unquestionable integrity, of known probity, of faith and patriotism, and with recognized competence in their respective fields.
Second.
Yeah, so it has been moved and seconded
Appointed na naman sila.
that the amendment that we delete line 41 to 46
And retain.
and retain the last sentence. Thank you, Mr. Chair, approve.
Mr. Chair, also,
Elena, please.
thank you. Also under section 4, next page, lines 13 up to 18 inclusive. It reads, the contemplated executive director as well as members of the secretariat or the staff and personnel of the commission should also be subjected to the no conflict of interest safeguard as a requirement for appointment. Then subparagraph F says the executive director must have an extensive experience in the field of law, enforcement, anti-corruption, or public administration. I believe that these portions are misplaced. It should not be in this portion. I move to transpose this portion to the provision, to the section on the secretariat. Kasi parang yung nakaagad about executive director when we have not said anything yet about the position of executive director, because this particular subparagraph on the subparagraph E pertains to the certain limitations or certain disqualifications of members. So wala po dito, misplaced po ito, ilalagay po ito dito. So the portions that I read should be, so submit, be transposed to section 11. So alisin po natin yung lines 13 to 18 at ilagay po natin under section 14 all the way down sa, hindi ko na po alam kung anong page ito, wala pong naka-indicate dito sa papel, but under section 11, secretariat. Kasi nga po, yung executive director nasa secretariat. I so move.
Second.
Subject to style.
We approve that nung kanina
Page 5, section 8.
as UP Law Center to comment.
Good afternoon, Mr. Chair. This is our first time participating in the hearings of the committee, but we are thankful for the opportunity. We just received the invitation just this week. Okay. Our position on this matter, Mr. Chair, actually, our position paper was a narrative of our recommendation. So I think when it was inserted here, it did not take into consideration the wording that would be proper for a bill. So but it is our recommendation that the qualifications, duties, and functions of the executive director be clearly defined in the bill, because as it stands, there are no qualifications or specific duties and functions provided for the executive director. But we support the motion of Congressman Lima to move or transpose lines 13 to 18 to a proper provision later on in the bill.
Yes, it's supposed to be subject to style, and may I point out that under section 11, and that is under lines 10 to 12 of this page, the executive director, under the supervision and control of the chairman, shall execute and administer the policies and decisions of the ICAIC and manage the day-to-day operations thereof. So that is the specification of the general functions of the executive director. And that is why this representation moved for the transposition of those portions under section 4. Yun po yun. So nandun na po. Unless UP Law Center would put all the modifications, subject to style na lang po. All right. So I so move, Mr. Chair, yung transposition po.
And as first Attorney Alcantara, paayag ba kayo na transfer sa 11?
Yes, we have no objection. We agree with Congresswoman Lima, sir.
Okay. It's been moved and seconded that the proposed amendment of Honorable Lima deleting transposing line 5,
13.
line 5 to 18. 18, no?
Line 13.
Line 13, 13 to 18.
18 of the third page.
Third page. So this is
2, 4, 5,
4,
6,
section 4A.
11,
to lines 14,
line 14.
all the way down to 4, 5, 6, the seventh page. Kung tama po yung page, under section 11, subject to style.
Okay, thank you. Thank you, ma'am.
Thank you.
Mr. Chair,
Any more?
I would have one clarification and with reference to line 11 of section 4, letter E, which does not specify what degree of consanguinity or affinity. That sentence reads, I quote, a mandatory recusal must be required if any relative within the degree of consanguinity or affinity provided. While line 9 makes a reference to third degree of consanguinity, just for clarity, I think we should also specify in line 11 the degree of consanguinity or affinity. Mukhang ang intention nito ay third degree, ano?
The preceding proviso refers to third degree. So I suppose this also refers to third degree. Saan po galing?
Mr. Chair,
Third degree, right? Okay, so third degree po. So if you want to make it clear, maybe we can, so appropriate motion po.
Mr. Chair, for purposes of clarity, I move that we insert the word third before the word degree in line 11 of section 4E. And delete the word provided at the end of consanguinity or affinity provided. So my motion, if I may restate, is to delete the word, to insert the word third before the phrase degree of consanguinity or affinity, and delete the word provided that comes right after affinity.
And second, that you remove and seconded that we insert in line 12 and line 11 the word third before degree and delete provided
At the word after affinity.
for affinity. So, any more comment?
Mr. Chair, I move that we approve section 4 with all the amendments.
Second,
It has been moved and seconded that all the amendments
Section 4.
in section 4 should be approved,
Subject to style.
subject to style. Now proceed to
Section.
section 5.
Mr. Chair, with respect to section 5, line 22. I move that we add the words ill-gotten wealth after corruption, so that the sentence will read, the Commission shall have the jurisdiction to hear and investigate all allegations, complaints, and issues involving graft, corruption, ill-gotten wealth, malversation, and plunder in infrastructure projects, etc.
Second.
Ulit lang po.
Yes, I move, Mr. Chair, that the words ill-gotten wealth be inserted after the word corruption in line 22 of section 5, so that the sentence will read, I quote, the Commission shall have the jurisdiction to hear and investigate all allegations, complaints, and issues involving graft, corruption, ill-gotten wealth, malversation, and plunder, etc. End quote.
It has been moved and seconded that line 20 after
22 po.
22, line 22,
Insert the word.
insert the word ill-gotten.
Well,
Ill-gotten wealth.
yes.
Hereby approved.
Mr. Chair, just a point of clarification.
Okay. Before we proceed, we'd like to acknowledge the Honorable Paulo Henry Marcoleta, Sagip Activist. Thank you for coming. Director Osaka, you're recognized.
Thank you, Mr. Chair. I'd just like to, for clarification, I believe in section 3 it was amended and limited that the scope will only cover infrastructure projects funded by national government. It's section 3.
Section number.
Section 3. Yeah, and section 5, it funded by national and local government. And another clarification, is it correct to interpret this that this will also cover infrastructure projects by government-owned and controlled corporations?
Osaka, wala pa tayo sa section 5.
Section 5.
Nasa section 5 po. Kasi napansin po, if I may, Mr. Chair, napansin po ni E.D. Osaka na meron dito nakalagay na phrase funded by the national and local government. Kanina po, when we were discussing section 3, we said section 3, an independent body tasked to investigate anomalies in all government infrastructure projects. It was clarified by Congressman Erice that we better just, the commission better just focus on national, but we didn't deem it necessary to still put it there. Diba? But now we're seeing in section 5, it is actually for both national and local government. And then nagtatanong nga po si E.D. Osaka kung it will also cover those committed or attributed to government-owned and controlled corporations.
Mr. Chair, earlier I think that whether it includes locally funded infrastructure projects, and as pointed out here by Congressman Lima in line 23, it says here under section 5, national and local government. So meaning that includes infrastructure that are funded from funds coming from the coffers of the local government.
Mr. Chair, we just have to reconcile both, no? Kung talagang national and local, then it has to be in both sections. But if it's only national, then we will have to amend this. We will have to delete the word local, no? So I think the body will have to decide what is the pleasure of the body.
We have already discussed that I already mentioned earlier that with the present setup of the ICAIC, it will be very, very hard for them to cover all the 1,600 municipalities, 42,000 barangays, which are all part of the local government units. So ito naman pong kontrobersya na ito ay born out of the national government projects. So I would suggest na i-delete na po natin yung local government, but yung po mga GOCCs, actually po yung mga GOCCs is meron po mga mother agencies yan. So I think yung GOCCs is part of the task of the ICAIC. Nakakalito na kasi may ICC, may ICU.
Any comment from Honorable Lima?
Just by way of information, because anyway, this is a separate chamber. In the Senate version, because I think they approved already the committee report as of yesterday. In the Senate version, it appears to cover all. In the Senate version, where is that? Okay, it says in section 4, part of section 4, such investigation shall cover all projects implemented by the national government, its agencies and instrumentalities, local government units, and government-owned or controlled corporations. By way of information only, Mr. Chair.
So, Mr. Chair, ano ba ang Senate version that they approve sa committee report?
Yes, yesterday, the committee report number 16.
Okay.
The substitute bill for Senate Bill 1215.
Okay.
This was, I think, yesterday, November 12, 2025.
Mr. Chair, if we will include the local, baka masyadong matambakan po ng local. Yun lang. I'm not saying we should not include it. What I'm saying is binigyan natin sila ng 3 years, tapos i-add natin, imagine how many local government units are there, no? So baka matambakan sila doon sa local. So yun lang po ang concern ko. I mean, syempre, mas gusto natin na ma-cover yun, pero we will be practical about ilan lang sila, ilang tao lang, tapos yung timetable na binigay natin sa kanila. Baka mas magandang mag-concentrate doon sa national government projects and the all instrumentalities of the national government.
Meron na tayo, there was already a motion to delete this as recommended ko.
I think, Mr. Chair, I think we should all just talk with the BICAM. We should discuss sa BICAM. Kasi po, yung kaming mga district representatives, alam natin yung what's happening on the grounds, or how many projects, yung mga local governments, especially kung maraming nag-aaway ng mga local governments, papadala lahat ng mga reklamo nila sa committee, sa commission, matatambakan talaga sila ng trabaho.
Mr. Chair, pag sinabi po kasi natin local government, it includes the barangay. So hanggang barangay level, doon sila magreklamo, no? So I think if the body will agree,
that we concentrate on the national government projects and the instrumentalities of the national government projects, Mr. Chair. Yes.
Mr. Chair, your comments, if I may make a manifestation, this bill was formed to broaden the powers of the commission. Ang naisip ko lang po, if we elite local governments, baka may loophole eh. Sabihin sabihin ng iba, lagay natin sa LGSF. Nasa local government na, hindi nasaklaw ng komisyon. So, sorry. Okay. It's beyond your jurisdiction. So, if I may, include din natin local government projects, including foreign assisted projects na employ the local contractors.
Okay. Well, we're talking here of billions of projects. Hindi magiging sa budget approval pa lang pag LGSF makikita mo na kagad eh. So may checks na diyan. Problema natin, this is an investigation. 235,000 projects from 2010 to 2025. So yun yung priority actually yan yung priority ng independent commission. Now, ibibigay natin lahat yan yung mga problema na yan sa commission, baka instead na mabigyan natin sila ng tulong, lalo mahirapan sila na i-perform yung kanilang task. Meron naman po tayong ombudsman. Yung mga local governments, they can always go to the ombudsman. Any private citizen can go to the ombudsman. Ang problema natin dito, yung nangyaring ghost projects, yung mga malalaking insertion, diversion, amendments na talagang pinagkitaan. So, siguro, dapat dito naman natin ibigay, ito muna yung i-resolve natin. We cannot fight so many battles. Ito yung pinakamalaking battle natin eh. So, why would we burden the commission with 42,000 barangays, 1,600 local government units?
Ang proposal ko po, Mr. Chair, okay, we can delete now this phrase in all, in both, saan na ba yun? Where is it?
So, just a clarification.
Where is it? Here?
Projects emanating from congressional districts, are they considered local or national?
Hindi.
Projects
International.
whose opponents are congressional districts, are they local, considered local or national?
Where?
National, dito na kasi pinditin ng araw sa nila. Dito, local lang ang nila.
Mr. Chair, all projects are line items in the GAA. So yung mga congressional initiatives, nakalagay po yan sa GAA. So it's part of the national government project.
Every line item found in the GAA, I consider national. Okay, thank you.
The concern of Congressman Marcoleta, why don't we just word it as nationally funded projects? Kasi kung ang concern niya is LGSF, nationally funded yun. So kahit linipat po yun sa local government, kasama po siya dito. So para yung concern ni Congressman Marcoleta ay ma-address natin, yun po ang proposal ko. So yung wording natin will be nationally funded instead of nationally implemented. So pati kasama po yung LGSF
kasama po siya. If the body will agree. So if someone has to present a motion.
Emotion.
Because I am not a member.
I second the motion of Congressman Tiangco. Let me amend that, pursuant to the suggestion of Tiangco, may I suggest to reword what is stated in the bill, to cover local, nationally funded
To be very clear, if I may, sabi na ko na lang po. Okay, I move to, amend, line 23, third page, under section 5, by inserting the phrase nationally funded after the word in and before the word infrastructure, and delete the phrase funded by the national and local government. And that would affect both lines 23 and 24. I so move, Mr. Chair.
second.
Subject to style.
Any comment from DPWH? Kayo po ang nag-comment eh. Propose eh.
We agree with the, what you call this, motion of Congressman Lima, Mr. Chair.
Subject to style.
Okay.
Amendment.
Amendment is hereby approved, subject to style.
Mr. Chair, I move to approve section 5 with all the amendments.
Second.
Mr. Chair, before we, if I may, I have one, just a few more proposed amendments, for section 5. With respect to line 7 of section 5, letter C, I move that we insert the phrase "it has acquired ill-gotten wealth" after the word "she," so that this section C will read as follows, I quote, "To investigate any property or funds of any person when there is reason to believe that he or she has acquired ill-gotten wealth or is committing or attempting to commit, etc." So that the rest of the
Mr. Chair, if I may, nagka-doble po kasi yung section 5 eh. Section 5, scope and jurisdiction, yun po yung subject ng motion na pwede po natin na-approve na po yun.
I'm referring to section 6.
Section 6 na po, so nagkamali. We have to remember to section 6 yung powers and functions. Opo.
So I withdraw my motion, Mr. Chair. Dalawa nga pala.
So, Mr. Chair, I reiterate my earlier motion that we approve section 5 with all the amendments. Mr. Chair,
Subject to style.
Mr. Chair,
There's been a motion duly seconded to approve the section 5 with all the amendments.
There's a motion, seconded, section 5
It's approved.
is approved,
Including the amendments.
kasama po ang amendment ito,
Subject to style.
subject to style.
Mr. Chair,
Please identify, Mr. Ombudsman, you are recognized.
A few observations, Mr. Chair, on section 5.
Ilapit lang yung mic ko.
Speak loudly.
Mr. Chair, a few observations on section 5, Mr. Chair. With the permission of the chair. Yeah, po.
Hindi narinig po, ilapit lang po.
With the permission of the Honorable Chair, a few comments po on section 5. Yes po. On section 5 po, Mr. Thank you, Mr. Chair.
Pakilagasan ng boses sa pano.
The Office of the Ombudsman respectfully reiterates the comment respecting the mode of referral, Mr. Chair, on
Attorney Rapana.
pertaining to pending cases. Lakas na, mahina. Mr. Chair, since the end purpose in ICAIC for section 5 is, I quote, for the purpose of filing administrative, criminal, and civil cases. And considering that this end purpose has already started to take traction in investigative and prosecutorial agencies like the Office of the Ombudsman, it would be in the interest of the speedy resolution of these cases to have these cases not referred back to the or referred to the ICAIC, considering the proceedings ongoing with the Office of the Ombudsman or other investigative and prosecutorial agencies pertaining to these complaints, with the filing of a formal complaint by the previous with the existing ICI, or those complaints filed by DPWH represented by Secretary Vince Dizon already pending with the Office of the Ombudsman. I think it would be in the interest of non-duplication of functions, and it would not unduly hamper the full swing of this proceedings before the Office of the Ombudsman if these cases would be reheard or allowed to return with all the records to the ICAIC. At all events, the terms of such it might not be referral, but the terms of coordination, if that is the more accurate term that would capture the essence, is already mentioned under the last paragraph of section 5. The terms of coordination shall be mutually agreed upon, etc., etc. And the final provision under the first paragraph that nothing in the law shall be construed in curtailing. I think that would operationalize the coordination between the Office of the Ombudsman and the ICAIC with respect to pending matters, Mr. Chair. So it is respectfully suggested that it may no longer be necessary to include a specific provision on including those already pending investigation under lines 26, 27, and also the pending cases under lines 32 and to 35, Mr. Chair, for the consideration of the members of the committee. So it would be the terms of the not referral, the terms of coordination might be a proper term in order to allow the proper working arrangement between the constitutional body, which is the Office of the Ombudsman, and the ICAIC, and how to move forward these cases without duplication as to pending cases and without with due regard to the functions of both agencies, Mr. Chair, for the consideration of the Honorable Committee.
Mr. Chair, before we decide on the matter, may I ask the Honorable Assistant Ombudsman this question? Because it's now worded, it says, including those already pending investigation by other investigative and prosecutorial agencies of the government. So when we say pending investigation, that would not cover filing. I mean, that would cover, pag sinabi po natin pending, file pa lang, is that pending already? Normally, yes, correct?
It depends, Mr. Chair, on the evaluation by the ombudsman on the complaint, because the complaint may not proceed directly to formal proceedings. It may be referred to the fact-finding.
Kasi po, yung first stage, according to your own rules, according to the rules of the Office of the Ombudsman, kapag final ang isang complaint, ang first stage would be fact-finding, field investigation.
If the evaluation po is for fact-finding, it might proceed po to,
So, evaluation muna po.
yes po, Mr. Chair.
So, if a complaint or a case or a referral is under evaluation, is that deemed pending?
Yes.
I think so, Mr. Chair.
So there lies the complications there lies the problem. Kasi we may agree with you kapag yung pending ay talagang tapos na kayo sa fact-finding and preliminary investigation na kayo. So it might be impractical na nakukunin ng ICAIC. Pero kung nasa initiatory pa lang, o lalo na kung wala pa talagang aksyon, evaluation pa lang, hindi mo pa pwedeng kunin na rin yan ng ICAIC. So those are the things that we need to. So, Mr. Chair, may I move to suspend for us to.
Do you have any, Congressman Lima?
Yes, Mr. Chair, I have a motion to propose in line with the comment of the Assistant Ombudsman. I move to delete the portion under under lines 26 and 27, which reads, including those already pending investigation by other investigative and prosecutorial agencies of the government. It would seem that it would be more appropriate and it would be less problematic actually, and understood naman po this the portion, the commission should have the jurisdiction to hear and investigate all allegations. And to be consistent with the last portion of the paragraph section 5, first paragraph of section 5, provided however that nothing in this law shall be construed as curtailing or diminishing the investigatory, prosecutorial, or disciplinary powers vested by the Constitution, the Office of the Ombudsman, etc., etc. So I so move to delete that portion under lines 26 and 27 under section 5, page 3.
Any second motion?
Second.
Additional vote is that you will seconded that line 26, 27 be deleted.
Mr. Chair, may we further hear out the Assistant Ombudsman with respect to the second paragraph of section 5.
Assistant Ombudsman, please.
Thank you, Mr. Chair. With respect to the second paragraph of section 5, in line with the jurisdiction of the ICAIC to hear and investigate all allegations, complaints, and issues. And since the matter of pending investigation under the first paragraph was already deleted, the limitation or the indication of a threshold amount of 50 million under the first sentence of the second paragraph, under the first sentence be likewise deleted. And then the second sentence of the second paragraph, the terms of, instead of such referral, the terms of coordination be adopted, Your Honor, instead of referral. The terms of coordination shall be mutually agreed upon with the commission. For the consideration of the Honorable Committee, Mr. Chair.
So we are still going to retain the first sentence of the second paragraph. You need only to delete the threshold amount of 50 million. Is that it? Is that going to be inconsistent with our deletion of that portion I indicated in my earlier motion, including those already pending investigation by other investigative and prosecutorial agencies of the government, because the first sentence of the second paragraph says, all complaints involving corruption in infrastructure projects amounting to 50 million and above pending the regular investigation and prosecution agencies shall be referred to the Commission on Effectivity of this act to avoid duplication of investigation.
Mr. Chair, to be consistent with the earlier deletion, the first sentence of the second paragraph is suggested to be deleted.
Deleted as well for consistency. But the second sentence can be retained.
May be retained, Mr. Chair, with the replacement of the word referral to coordination, Mr. Chair. The terms of coordination.
The terms of such coordination.
Yes, Mr. Chair.
But there is no predicate for this sentence.
The
terms of such coordinations.
I think the proviso on.
Is there a predicate for that sentence in light of our intended deletion of the first sentence in the earlier phrase in the first paragraph?
The phrase, the terms of coordination could refer to the last proviso under the first paragraph, Mr. Chair, on the terms on how not to curtail or diminish the prosecutorial or disciplinary powers.
Okay, so subject to style. Subject to style in relation to that. In light of that clarification, Mr. Chair, may I now make the formal motion? So may I reiterate the earlier question? So this amendments pertain to both to section 5. I move that the phrase, including those already pending investigation by other investigative and prosecutorial agencies of the government, found in lines 26 and 27 of page 3 and under section 5, be deleted. Accordingly, the entire sentence of the second paragraph, also of section 5, and these are lines 32 up to 35 inclusive, which read, all complaints involving corruption in infrastructure projects amounting to 50 million and above, pending with a regular investigation and prosecution agencies shall be referred to the Commission upon effectivity of this act to avoid duplication of investigations, be deleted. And the last sentence be retained, subject to style, to be consistent with the preceding sentence of the first paragraph, the last sentence of the first paragraph. I so move, Mr. Chair.
And second. Noted Madam De Lima. Line 26, 27. And line 35, 32 to 35 will be deleted. This is approved. Next,
Powers and functions.
let's move to powers and functions. This is section 6. Kamali kasi tayo dito, 5.5 eh.
Hindi pinapapalitan. Ayan na siya pinapalitan.
Any comment?
Section 6.
Section 6, powers and functions.
Yeah, Mr. Chair,
Congressman Jokno, you're recognized.
with respect to section 6, letter C, appearing in lines 7, 8, 9, and 10, I move that we insert the phrase has acquired ill-gotten wealth, or in line 8, after the phrase he or she, so that the entire subsection C will read as follows: to investigate any property or funds of any person when there is reason to believe that he or she has acquired ill-gotten wealth, or is committing or attempting or conspiring to commit, etc., until the end.
Second.
It has been moved and seconded at lines 7 to 8.
Insert
Insert the word
acquired
acquired ill-gotten wealth. Hereby approved.
Thank you, Mr. Chair. I have one other proposed amendment. This is with respect to section 5E found in lines 6, I'm sorry, section 6E found in lines 25, 26, and 27, that we delete the remainder of that sentence and only retain the first part to read as follows. Section 6E, administer oath and take testimony, period, and deleting the remainder because we already have a separate proposed provision found in section 7. Period na ba?
So,
Second.
The motion, seconded, remove and seconded that line 25, it's administer or take testimony period and delete the
rest of the file.
Mr. Chair, one more, thank you, Mr. Chair, one more proposed amendment. This is with reference to section 6, letter L, found in line 8, 15. In particular, line 9, after the acronym AMLC, we insert the Office of the Solicitor General. If I may explain, this is simply for purposes of filing forfeiture proceedings if the commission uncovers evidence of ill-gotten wealth. So that the subsection L found in line 8 up to 14 will read as follows, I quote, initiate administrative cases and refer verified complaints and official reports to the AMLC, and then we insert the Office of the Solicitor General, and then the Securities and Exchange Commission, etc.
Second.
It has been moved, seconded, line 8,
And
letter L, initiate administrative cases
verified complaints
and the verified complaints
and insert Office of the Solicitor General.
and insert
Office of
Office of the Solicitor General. Hereby approved. Mr. Chair. Yesterday during our technical working group, the body discussed and considered my proposal of including the recommendatory power of the commission to cancel passports. But now it does not appear on the substitute bill. May I inquire on the absence of such proposal? Congressman Dilema? Honorable Dilema? Okay. Kasi sabihin nila, hindi tayo seryoso eh. Yung mga nakaalis na, hindi natin mapabalik. Mga kanina Madam Leila, possible naman yung proposal na ito.
Yes, because it's already there. Actually, the Philippine passport law is actually there in the power of the DFA under the ground national security, although hindi pa ko yan na-exercise. So,
Explicitly
close it here, just like yung pagbigay natin ng whole departure order. Okay, why not? We can, the leader of has no objection to that.
No. The only reason I was contemplating on adding it. The only reason I didn't add it is because my stand was that it is an inherent power of the DFA based on RA 1190. And it's in line with the Constitution that the right to travel can be prevented based on national security. So that's the only reason I did not include it here. Kasi ang worry ko lang, I have no objection. Ang worry ko lang is baka habang hindi natin napapasa to, sabihin ng DFA, ay hindi pa pwede kasi hindi na nga linalagay. Yun lang yung worry ko.
Yes, and since
I don't want them to use it as an alibi na kaya nilagay sa batas na yan kasi wala kaming power. Yun lang yung reason na I didn't add it.
okay, and since bibigyan na natin sila to issue whole departure order, itong ICAIC, then we might as well also give them now the power to cancel passports. So perhaps we can put that, nasaan yung, kasi nasa subparagraph H po, yung issuance of whole departure order. So perhaps you can place it either before or after that subparagraph. So, after.
Okay, at least yung first step is kung nandito sa bansa, issue a whole departure order. Yes, na we cancel the passport. Recommend the cancellation of the passport.
Recommend the cancellation.
Mr. Chairman, I propose the appropriate wording.
Yes.
To recommend to the Department of Foreign Affairs the cancellation of passports subject to and in compliance with the qualifications and powers under RA number 11983.
Yes.
Yep.
In a motion, please.
Second. So we will make it subparagraph I. And move accordingly yung next, yung I magiging J na. So subject to style.
Calculator, please submit lang yung one. Submit lang dito.
Mr. Chair, if I may. Mr. Chair, if I may. So far as Section 6, specifically line 8, may I suggest that the word administrative be changed into appropriate cases because of the introduction by what you call this Congressman Diokno of the Office of the Solicitor General insofar as ill-gotten wealth is concerned. And the nature of these cases appears not administrative cases but civil or criminal cases. Thank you, Mr. Chair.
Section 8.
Sa section 8 ko yung
Section 6, Your Honor, Section 6.
Section 6, letter L,
Letter L, line 8.
Yes, yan po, yung sinasabi nila. Yes, Mr. Chair, in line with the manifestation of Attorney Fernandez of the DPWH, I move that we delete in line 8 the word administrative and replace it with appropriate.
Okay, line 8, it's line 8.
Thank you.
Appropriate.
Shall we move and seconded?
Mr. Chair, if I may, with respect to section 6M, underline 16, may I respectfully recommend to the committee the insertion after the word monies, the words deposits, comma, investments, comma, insurance policies, and also, Your Honor, underline the succeeding line, 17. After the word properties, we insert comma, and then after the words monies, pre-monies, comma, and virtual assets. Yes, sir. And may I also express to the honorable committee a possible question in the plenary in relation to subsection M about the nature of the freezing and sequestration power of the commission. Will it be provisional in nature? And if so, how long would the freezing and sequestration be effective? And another possible question is that prior to the expiration of the period, assuming there will be a period, what should the commission do to effect a permanent, or should I say, recovery or forfeiture or permanent freezing? And also, another possible question, I think, would be the degree of evidence that would guide the commission in determining the exercise of this power in relation to the ownership of a person over the items enumerated. In relation po doon sa last comment ko, there's a mention of somewhere in the earlier part of section 6 about reason to believe, I guess. I'm not sure if the committee could consider that reasonable belief as a degree of evidence that would guide the commission in the exercise of this provisional remedy or the seizure, sequestration, and issuance of an attachment order.
Mr. Chair, I think it will all be provisional because the ICAIC will just file it to the ombudsman. So the final decision will be in the Sandigan Bayan.
Honorable Lima, please.
We can always, of course, adopt also what was pointed out by Attorney Trejo. This phrase under subparagraph 3, there is reasonable ground to believe that individuals are criminally liable. The transfer evidence and findings in the course of its investigation, there is reasonable ground to believe that individuals are criminally liable. But I guess, as pointed out by Congressman Erice, it would be more practical, and because if we put so many such requirements, especially with respect to evidentiary requirements, evidentiary standards to an investigative body at this point, baka magiging mas complicated pa. Why not leave it to the regular prosecutorial agency? Ba? So we appreciate, of course, the comments and the recommendation. Thank you.
Mr. Chair, may we maybe get the opinion of the ICI Executive Director regarding the matter?
Yes, Your Honor, Mr. Chair. Wala kayo usapan. Yes, Your Honor. With regard to Section M, this has something to do with asset preservation because we want to ensure that any ill-gotten wealth or property connected to these anomalous projects be preserved in the meantime that there's no final determination by any judicial body. So I believe this is necessary so that we'll be able to have complete restitution with regard to that. Now, as far as the quantum of evidence is concerned, probably that can be tackled in the internal rules and regulation as far as the proposed commission is concerned. Thank you.
Need to put any qualifying phrase, please.
Talagyan dyan ang PLEYTO. Kanina ko pa sinasabi. Kanina ko pa sinasabi.
Ano to? Pinatanong ako nito. Professional dilim. Ano to yun, ma'am? Wala na pa.
Meron na?
Other comment, let's move to the next.
Nasa 7. Actually, sa section 7 na dapat. Right of whistleblower.
Section 7.
Right of whistleblower.
Mr. Chair,
Hindi yan sa nagkamali na kasi.
Pati kanyo, mali-mali.
Mr. Chair,
Let's move to section 7. Right.
from SEC po.
Identify.
Attorney Lacanaria from the SEC. We just want to clarify po on the power of the ICAIC. Under subsection M, line 22, on its power to issue closure or revocation of registration of establishments which are found to be responsible for anomalous infrastructure project. We would just like to clarify if the word registration pertains to certificate of incorporation or registration issued by the SEC to corporations. If so, we suggest that this should be done in coordination with or be properly endorsed to the SEC by the ICAIC. Thank you, Mr. Chair.
Clarify from the representative from the Securities and Exchange Commission. So she's actually suggesting that before issuing closure or revoking the registration of the establishment involved, there should be prior coordination with the SEC or prior clearance with the SEC. Is that the proposal?
Not necessarily po, Mr. Chair.
Your recommendation?
We suggest that, we just want to clarify if this includes, certificate of incorporation issued by the SEC to, corporations. And if ever po na it pertains to certificate of incorporation, we just suggest po na this should be done in coordination with or be properly endorsed to the SEC by the ICAIC po. Bilang kami po, under the SEC and the ICC, we are the primary grantor po ng primary franchise po ng corporations na ito.
That can be the necessary consequence if you revoke the registration of the subject establishment. That you also revoke the certificate of incorporation and hence can be endorsed now to the SEC.
Yes.
Di ba?
Same with the language po ng subsection O po na parang CIC recommend na sa PRC po yung automatic cancellation ng professional license po ng professionals found to be responsible sa anomalous projects po.
Okay, so directly recommend to the Securities and Exchange Commission?
Closure sa ano dyan. Hindi, not necessarily. Diba?
Any comment from ICI?
Ano ang process? Matagal ang process ng closure. If you just suspend,
ICI, please.
suspend 2 minutes.
It is suspended.
Mr. Chair. Hindi, baka pwede nga, nag-aalis kasi siya, wala sa manifestation.
Mr. Chair, may manifest because first permission to leave for some emergency and second,
Sige, i-release siya muna.
Mr. Chair, I seek your permission to leave as under some emergency and may manifest that if the sponsors will allow to include me as one of the sponsors of the CPO.
Thank you
very much.
Thank you. Thank you, Congresswoman. Well.
Mr. Chair, I will recognize this upon a further discussion with Attorney Laganario of SEC. We find no need to touch or make any modification as on subparagraph N at this point. Any nuance on this can be addressed in the IRR of the law. Thank you.
Mr. Chair, there are no more amendments.
Mr. Chair. If I
Comment from the ICI.
just a backtracking on paragraph M, it mentions accumulated by persons. Can we also qualify this as natural and juridical persons because there might be corporations that will be involved in these anomalous projects? Thank you.
Mr. Chair, may I also to section 4. Yesterday, the PWG suggested, the body suggested that in the selection process of the members of the commission,
a body should be, must be formed to prepare the short list of qualified candidates. And it was agreed yesterday that a selection committee composed of members of the House and senators, including the Senate President, shall constitute the selection committee who will submit the candidates for the five committees. I wonder why is it not included in the substitute bill? And to my surprise, there's a new provision here. But later I learned that it was deleted accordingly. If I may read line 41, letter C of section 4, and if I may read, to ensure independence and impartiality, the members shall be chosen from a list of nominees submitted by the IDP, by the chairperson, the Philippine Institute of Certified Public Accountants, or PICPA, the Philippine Institute of Civil Engineers, United Arbiters of the Philippines, and a recognized National Coalition of Good Governance and Anti-Corruption non-governmental organizations. This is a good suggestion, but however, I learned that it was consistently deleted also. Only to retain the last phrase. Sentence, each member shall be of good moral character, of unquestionable integrity, of known probity and patriotism, and with recognized competence in their respective fields. My only apprehension, Mr. Chair, if we leave the appointment up to the President, nawawala yung independence ng body na ito kasi they will be beholden and indebted to the appointment of the executive. So I proposed yesterday, there's a selection body that will submit a short list of qualified candidates. And to my surprise, it's not found in the substitute bill. Mr. Chair, thank you.
Mr. Chair, the particular matter, the particular provision was actually discussed earlier. A motion was properly made, it was seconded, and it was approved. So I guess the manifestation now, the Honorable Paolo Marcoleta is in the form of a motion for consideration. So can we ask please the Honorable Marcoleta to put it in a formal motion so that we can properly vote on it, because it was discussed earlier and it was seconded and it was voted upon. Para lang po malinaw ang ating proceedings.
That was moved earlier and seconded po, if I may seek clarification.
The deletion of that portion.
I know the reason for the deletion of such provision, Mr. Chair. If this is the only way we can ensure the integrity and independence of such body, may I move to item C under section 4. Reconsider the reinstatement of section 3 under section 4 of the substitute bill, Mr. Chair.
Mr. Chair, I think the reason why it was deleted earlier when Congressman Marcoleta was not here was that hindi po kasi maliwanag kung ano ba to, collectively or individually po. Ang ibig sabihin, yung po bang IBP ang mag-nominate ng justice, yung po bang so individually po. Individually. So ang gusto po ni Congressman Marcoleta is yung justice IDP. So hindi po sila collective, hindi sila bubuo ng isang body. So ang mangyayari, yung justice IDP ang mag-nominate, yung accountant PICPA, yung engineer ICAIC, ngayon yung academe, sino po mag-nominate? Mr. Chair, the very reason is that it would take time, so much time to convene all these bodies, these associations. For example, kung ang nominee, yung nominee ba ng civil engineers,
Architect nag-away.
tapos the architect, UAP, mag-recommend sila, mag-aaway pa lahat yan. Tapos kung academe, lahat ng schools. So to convene them will take time. Baka doon pala, 6 months lang, tapos na, ubos na yung oras natin.
Mr. Chair, ang takot ko lang kasi pag nasunod dito ang item B, the members of the commission shall be appointed by the President. Okay, nang bahala sa voice ko, go easy on my voice. Kung hindi naman sa proseso man lang ng pagpili ng mga miyembro ng commission natin.
Mr. Chair, the present composition of the ICI were appointed by the President. And so far, wala naman po tayo nakikita na hindi maganda. From the Executive Director to the Commissioners, okay naman po yung performance nila. Kulang lang talaga sila sa mga powers. So, bigyan na natin. Anyway, sa transitory provision, they will be retained as the holdover members. So, may additional lang from the business sector and the academy. And we should also give trust to our president. He is our president. He was elected by 31 million Filipinos.
Despite very low trust rating, he is now enjoying. We should still trust the president. Is that what you're saying? Congress. Anyway.
Your Honor, there's a motion. You made a motion.
Yeah, I want to reiterate my motion to reconsider item C, section 4, to provide a more balanced and transparent selection of the members who will constitute this commission. Mr. Chair.
Mr. Chair, I object because it will
Anybody would second it? I'm sorry, Mr. Chair.
There is no second.
Second the motion?
No.
Yun, isang araw lang naman po sila na magbobotohan para piliin yung kanilang kandidato for IDP, for PICTA, and so on.
So, Chair, there was no second. I think the motion for consideration is defeated. So we might as well proceed. It's already getting late.
There's no second, the motion. Mr. Chair, I still reserve my right to propose such amendment at the plenary level.
Yes.
Thank you very much, Mr. Chair. Thank you, Congressman Coleta. Any more comment, Mr. Chair?
Chair, can we go back to what was pointed out earlier by
ICI.
ED Hosaka with respect to the proposed insertion of the phrase natural and juridical? Yeah.
Cellphone section, what line po?
Subsection N, line 17. I move,
M.
I move to insert the phrase first comma, natural and juridical, comma, after the word persons and before the word involved. Thank you.
Subsection M.
And line 17
17.
and 17.
Okay.
I-approve ka? I-approve. Hindi ko alam kung sila yun.
Letter M.
Letter M, line 17.
Ito sa
Is approved.
letter
Okay.
M, natural or juridical. Sons, natural or
Natural or
ito, insert, natural and
insert natural and juridical persons. Okay, approved.
Yes, sir. Silap natin. Andito po kasi sa
Mr. Chair. Mr. Chair.
Si San Ombudsman ka pa namin, Sir Romais.
Thank you, Mr. Chair. It has been observed that the version of the bill authored by Representative Tiangco empowered the commission the power to directly file a criminal a complaint. It appears, however, that it has been downplayed to a recommendatory role. So if the commission we submit to the honorable committee if the commission would be empowered to also directly file a complaint or initiate a criminal complaint under subsection J, Mr. Chair. If the power is only to recommend to the DOJ or the Ombudsman for the prosecution, or does it have the power to initiate criminal action before the DOJ or the Ombudsman for the prosecution of the criminal charges, Mr. Chair?
Congressman Tobias.
No, I think if I understand it correctly, the office of the ombudsman has no objection to the direct filing. Is that understand it?
Yes, Mr. Chair. In fact, it would speed up the process if the fact finding has been completed at the commission level. If all data or evidence is already there, it's just a matter of drafting a formal complaint under oath and then file it with the DOJ or Ombudsman. And then the formal process will already set in, Mr. Chair, rather than mere reports or documents being submitted to the Office of the Ombudsman. And if it's in an administrative case, Mr. Chair, if I may add, the provision for the immediate preventive suspension would also help.
Yes, go ahead. Can you suspend us for 1 minute?
Upon further discussion during the suspension, I move to include the phrase on line 47, 1, 2, 3, 4, fourth page, under subparagraph J of section 6. Directly or before the word recommend. I so move, Mr. Chair. For the entire sentence would now read. The sentence would now read directly. I'm sorry.
Line 27.
recommend, I'm sorry, mali ho yung aking phrasing.
Recommend or directly?
Yes. May I, I move to include under line 47 of the fourth page and under subsection J of section 6, the phrase to insert the phrase directly file or directly file to the DOJ after the word recommend. So the entire sentence will now read recommend or directly file, or recommend to or directly file with the DOJ or the Office of the Ombudsman, the prosecution of any public official, government employee, contractor, etc., subject to style. Thank you.
Yes, we move and seconded. Line 7 and the J
Insert
to recommend insert
or directly
or
directly file.
directly filed to the DOJ or the Office of the Ombudsman. Okay. So from next.
Mr. Chair, if there's no more amendments, I move that we approve section 6 with all, together with all the amendments.
Subject.
So move, subject to style.
Because we move and seconded that amendment section 6.
Just clarificatory po, just to be very sure, naisingit na po ba yung naging suggestions ng AMLAC sa paragraph M? Yung monies, virtual assets, yung monies, okay na? Thank you. Thank you.
Okay.
Mr. Chair, I move that we approve section 6 together with all the amendments subject to style.
Second.
Can we move seconded?
Mr. Chair, yes, one clarification, point of clarification. So far as the period of preventive suspension, there is no period here. 90 days, 6 months, or 30 days.
Subsection
Section 6.
Section 6, subsection Q. Recommend to the appropriate authorities the immediate preventive suspension of any public official.
Yeah.
Now, how long will be the preventive suspension here, Mr. Chair? Thank you, Mr. Chair.
Congressman Tobias.
I think it should be decided by the appropriate authorities. Yes. So kung pinahin po yan sa ombudsman po ang mag-decide
Kung ano po yung period of preventive suspension. I think hindi po yung, because hindi naman sila mag-preventively suspend, no? They will file it with the appropriate authorities. So I think the appropriate authorities would be the one to determine the number of days of suspension, Mr. Chair.
That's very clear, Mr. Chair. May I reiterate my motion? My earlier motion. Mr. Chair.
Just a brief point, Mr. Chair.
Mr. Chair, if I may,
Mr. Chair, sorry, under the Office of Ombudsman, it's 6 months, Mr. Chair. The preventive suspension for under the Office of the Ombudsman is a maximum of 6 months. And the Commission may recommend to the Ombudsman the immediate preventive suspension. It should be accompanied by a formal administrative complaint. Because one of the requirements before the Ombudsman issues a preventive suspension order is that the evidence of guilt is strong. So there must be in order to issue immediate PS or preventive suspension, there must be administrative complaint filed by the Commission before the Office of the Ombudsman under oath, Mr. Chair. Thank you, Mr. Chair.
Mr. Chair, that's why the ICAIC will just recommend
That's the reason. Okay.
I get the point of the assistant ombudsman. Before they can order the immediate suspension, there must be a complaint, administrative complaint.
Mr. Chair.
Correct. Now, we're talking here about the powers itself of the ICAIC. Right. We can, as we have just tackled, we can recommend or directly file the administrative complaint, and even the criminal complaint, and then administrative complaint, we can directly initiate the administrative complaint. Now, ang question po natin dito, can we also directly order the immediate preventive suspension of those under investigation, subject of course to constitutional limitations? Yun po ano natin. Ano pwede natin? Kasi shall we wait? Kasi hindi pwedeng, we can only recommend the preventive suspension kung meron ng kaso filed with the ombudsman. Before that, we cannot, I think. Is that correct, Assistant Ombudsman?
That is correct, Mr. Chair. And I think the power of the commission under subparagraph L, that it has the power to initiate or otherwise stated, directly file administrative, I think the word administrative was changed to appropriate, initiate appropriate cases, etc. Before or any other administrative agency or quasi-judicial body for purposes of administrative action. This administrative action contemplated under this provision, Mr. Chair, as I understand, covers disciplinary and non-disciplinary. Meaning disciplinary, Office of the Ombudsman or the appropriate administrative agency, for non-disciplinary, revocation of license, etc. to before the proper government agency. So I think the commission is empowered under this subparagraph L to initiate as well or directly file also an administrative or appropriate case or verified complaint before the Office of the Ombudsman. Although the Office of the Ombudsman was not included in the enumeration of appropriate administrative agencies or quasi-judicial bodies in relation to the grant of preventive suspension.
And we can only recommend, the ICAIC can only recommend preventive suspension once it initiates administrative cases and not before that. Correct?
That is correct, Mr. Chair.
Okay.
Mr. Chair.
So ganun mo ba yun? I'm actually throwing this question also to my colleagues in the committee. Can we not consider also the power to directly order immediate preventive suspension, which is actually found in the Senate version? Order the immediate preventive suspension, subject to constitutional limitations of government officials under investigation by the Commission for involvement in anomalous projects. Ano lang po yan? I'm just throwing it, I'm just putting it on the table.
Identify. Yeah. I would support that, Mr. Chair, the proposal of Congresswoman Lima.
Please identify your...
Mr. Chair, I am Attorney Coranda from the Civil Service Commission. So under the rules of the Civil Service Commission, when an administrative case is filed with us, we can only issue preventive suspension when there is already a formal charge that is issued by the CSC. So I think the mere filing of a complaint with us or even a recommendation coming from the ICAIC would not be enough to trigger the issuance of a preventive suspension by the CSC.
Commission.
What can you suggest the commission and to the committee? Any suggestion?
Mr. Chair.
Hear the opinion of ACI.
Yes, Mr. Chair, Your Honors. I believe the purpose of this provision is for preservation of tampering of any evidence with regard to the investigation being undertaken by the ICAIC. So I believe with that said, perhaps is there a way by which under CSU that this can be in a way the purpose of the provision be accommodated?
Commissioner Tobias.
Mr. Chair, I think based on my understanding, ang sinasabi po ng civil services, they cannot preventively suspend someone kung wala pang case. But may I know if they're objecting if ICI will be given the powers to directly suspend or not?
That's why I'm asking Director Fonda or
Mr. Chair, there will be a question on the rights of civil servants eh. Kasi wala pa silang kaso,
yan, tinatawag civil service Director Fonda.
Yes, Mr. Chair, I think that rule requiring first the issuance of a formal charge emanated from Executive Order 292. So, if it would be the decision of the committee to have that power included here, then I don't think there will be some kind of legal impediment if that will be done.
So, may I be allowed to ask that the Civil Service Commission? Because I was looking online and it would appear that Secretary Dizon has preventively suspended several DPWH officials. So may I know, do cabinet secretaries have the power to issue preventive suspension orders on their own motu proprio?
Yes, Your Honor. The heads of agencies and other instrumentalities have concurrent powers when it comes to administrative discipline, concurrent with the CSC and the Office of the Ombudsman, and they are governed by the same laws and rules as the Civil Service Commission.
Kung sila po ang nakaka-uncover ng irregularities or anomalies, they have evidence, does someone have to file a complaint with them, or can they on their own immediately suspend and then issue a show cause order to explain to their employees?
They have motu proprio powers to investigate cases of their own employees po. Kasi I was thinking that they are part of the other investigatory powers mentioned in some of the provisions. Heads of agencies, they have disciplinary powers over their own officials.
Considering the answers of the Attorney Fernanda, I think that we could empower the commission itself to preventively suspend.
Mr. Chair, may I just ask one question to the civil servant? For example, one department secretary suspends an employee for hindi ka naman there must be due process, di ba? In the determination of his guilt. So once you preventively suspend yung rights niya, for example, his salaries, his benefits, di ba? It's something that would curtail his rights, di ba? Parang gano'n.
Please.
Mr. Chair, I think yung preventive suspension is not a sign of guilt, no. In fact, it is a measure done so that hindi niya tamper yung evidence, hindi siya makapag-impluensya, and once he's proven innocent, all those salaries and all his benefits will be given to him, Mr. Chair. That's the procedure of a preventive suspension.
As a representative from the DPWH, you're the director here, based on the suspension of DPWH officials.
So far as the DPWH is concerned, Mr. Chair, the secretary, being the disciplining authority, has the power to suspend its officials and employees.
Mr. Chair, the power to order preventive suspension is not something that is blanket. Nawala na siyang mga conditions. There must be a prima facie showing that the evidence of guilt is strong, but the continued stay of the public officer employee in the office may prejudice the investigation, tamper with evidence, influence witnesses, or otherwise just obstruct the proceedings, or the public officer employee's position or authority was used to or may be used to commit the acts complained of. May conditions po yan. There's not a blanket grant of the power to preventively suspend. But we have to, I believe we have to give that power, preventive suspension, lalo na tungkol doon yung the possible tampering of evidence and influencing of witnesses.
Okay, suggestion from the Civil Service Commission. Let's ask first yung Civil Service Commission. Kung wala silang objection, I would request the members of the committee to recommend to the appropriate authorities the immediate recommend or institute. No, I mean, if they have no objection, we have to ask the Civil Service.
Mr. Chair, I think under civil service laws, it is a fundamental rule that before the preventive suspension order can be issued, there has to be a prima facie case that is established, and that is after the conduct of a preliminary investigation. But I understand that at the level of the ICAIC, the proceedings are not in the nature of a preliminary investigation. So, although I understand the rationale and the real need to have these people suspended preventively in order to protect.
Mr. Chair, pero nabanggit niya po, nabanggit po kanina na ano po, Mr. Chair, nabanggit po niya na it's based on an executive order. Is my understanding correct, Mr. Chair? Yung ba yung sinasabi niyo it's based on an executive order? O iba po yun?
I believe, Mr. Chair, she was referring to EO P19, which is entitled an EO, but was promulgated by President Aquino in the exercise of legislative power at that time.
Because kinonfirm naman po niya kanina from the civil service that cabinet secretaries, heads of offices can actually preventively suspend for as long as nandyan yung mga conditions na yan, yung mga circumstances na yan, pinapasa showing. Di ho ba? So we can adopt that language in the EO, in the law. Opo. So,
Mr. Chair, sa akin, I would agree na ilagay natin anyway, it would be debated in the plenary and there will be a diagram. So there will be more legal arguments on this. So in the process of expediting the approval of this bill, we like to still put it out and let the plenary debate on this.
yes. Okay, now the proper formal motion. I move that we replace the wordings of lines of subparagraph Q that covers lines 34 to 36 of the fourth page. Is it fourth page? Fifth page. Replaced with these wordings. Order. The immediate preventive suspension, subject to constitutional limitations.
Yung
Comma.
letter Q.
So yan na po ang bagong letter Q. Unless po nabago na rin yung anyway, subject to style again. Whether the immediate preventive suspension subject to constitutional limitations of government officials under investigation by the Commission for involvement in anomalous, fraudulent, or grossly irregular infrastructure projects, provided that such preventive suspension may be issued only upon a prima facie showing that A, the evidence of guilt is strong, B, the continued stay of the public officer or employee in office may prejudice the investigation, comma, tamper with evidence, comma, influence witnesses, comma, or otherwise obstruct the proceedings, or C, the public officer or employee's position or authority was used to commit the acts complained of. Ang necessary, ano pong dapat siguro idagdag natin is the period. Kasi diretso na po tayo na nag-order ng preventive suspension, and therefore we cannot leave it to either the ombudsman or any other body. So provided further that preventive suspension shall be imposed for a period not exceeding, I hope the committee will agree, period not exceeding 6 months. Ganun. Okay po. Period. Thank you.
Pakisubmit na lang ma'am dito.
Second,
Subject to style. Thank you.
Thank you.
second.
Yeah. Okay, submit ma'am sa secretariat.
Mr. Chair. Mr. Chair.
Ano pala? From AMLA.
Yeah, going back, Your Honor, to sub-item L, there was an earlier suggestion for the replacement of the word administrative to appropriate cases. And in relation to that, we likewise suggest that the same word under line 12, administrative, be likewise replaced with the word appropriate to cover for future action that the EMLC can initiate.
Yes, yun lang po. Ginawa lang niyang pareho. Yung dating word administrative, because yung line 8 used to be worded initiate administrative, ginawa lang niya appropriate. So dito po, sa line 11, pinapagawa rin niya na para lang consistent. Line 12, pinagawa din ng appropriate instead na ano. Yes po. So someone has to make the motion.
Formal motion, Mr. Chair. I move to replace the word appropriate under line 8. And also to replace the word administrative with the word appropriate under line 8. And under line 12 to replace the word administrative also with the word appropriate. I submit.
The 6, di ba na-approve the whole hand?
Mr. Chair, I hope that this will be my last time to make my motion to approve section 6. Together with all the amendments, so moved, Mr. Speaker.
It says move to second then. Section 6.
Subject to style, sir.
The whole amendment of section 6 is hereby approved, subject to style. Section 7.
Mr. Chair, with respect to section 7, actually, ako po yung nag-submit nito at nag-propose kahapon sa technical working group. Overnight, I had some time to review it. I would, if I may, move that in view of what appears now in the substitute bill as section 7, that the following refinements be refined provision be put in place. I will quote the entire proposal and then submit a copy to the committee secretary. The section section 7 should be entitled "Right to Perpetuate the Testimony of Whistleblowers." Section 7A will be definition of whistleblowers. Whistleblowers are persons who come forward who have personal knowledge of acts or omissions, A, committed by public officers or private persons that may constitute graft or corruption offenses, plunder, malversation, or malversation in any infrastructure project, or B, ill-gotten wealth acquired by any government official from any infrastructure project. Section 7B, right of perpetuation of testimony. Whistleblowers shall have the right to have their testimonies perpetuated by filing with the regional trial court of the city or province where they reside a petition to perpetuate their testimony, in pleading as respondents all persons whom the whistleblower incriminates in the judicial affidavit attached to the petition. With the consent of the whistleblower, the appropriate prosecuting arm of the government may file the petition on his or her behalf. Section 7C, acceptance of perpetuated testimony. If the regional trial court is satisfied that the testimony of the whistleblower will aid in the prosecution of graft or corruption offenses, plunder or malversation in infrastructure projects, or the recovery/forfeiture of ill-gotten wealth, the RTC shall grant the petition and take the testimony of the witness, with notice to the respondents and reasonable opportunity for the latter to cross-examine the whistleblower. The examination shall proceed notwithstanding the absence of the respondent, provided he or she was duly notified of the hearing. And the last section, this is section C, number 2. The testimony taken shall automatically form part of the trial and shall be considered as part of the evidence by the court handling the plunder, malversation, or other graft or corruption offense in infrastructure projects, or the court hearing the civil forfeiture of ill-gotten wealth case, as the case may be.
Thank you. Honorable document, please submit to the Secretariat.
I so move, Mr. Chair.
Second.
Okay, submit lang po sa Secretariat. Honorable. Thank you.
Mr. Chair.
Tonight,
Mr. Chair, I would like to inform that, Mr. Chair, I move that we approve section 7. Together with the amendments. So move.
Second.
Mr. Chair, regarding the new section 8, I would like to inquire bakit po tinanggal yung exemption from criminal liability. O kasi yung section 7, formerly section 7, now it's section 8, exemption from criminal liability. 8 po, 8. Section 7, formerly section 7. But now it's section 8. After the word no criminal end was stricken off. So I just wanted to inquire, why was it stricken off po?
Mr. Chair, if you need. Yes, but actually we submitted our position paper just yesterday, Mr. Chair, and I think that's why it was belatedly included by the committee secretariat. But our position on this is that we should not be giving the commission such blanket immunity that they will be exempted from both criminal and civil actions. So our proposed our recommended provision actually was that no civil action shall lie against any member thereof for acts done in good faith within the scope of their official duties as contemplated in this act. We also compared this with an existing provision under Executive Order Number 1, 1986, which created the Presidential Commission on Good Governance. So the PCGG is actually just exempted from civil liability and not from criminal liability. So that's the basis of the UP Law Center, Mr. Chair.
Mr. Chair, may I ask question to can you cite a hypothetical situation wherein there will be a need to criminally prosecute members of the commission if they violated
Possibly, sir, Mr. Chair, data privacy considerations. Actually, we were also looking into uh, but this is not criminal in nature, but the commission actually can also be liable for grave abuse of discretion in their acts as a commission. So, but again, that's not, we just look into it. It's not criminal in nature. Kasi parang ano yung wording niya. So actually, our original recommendation was that no civil action shall lie against the members. But for the commission, dapat pwede siya, essentially.
example, Mr. Chair, for example, when a member of the commission was proven to, there are allegations that he got some bribe. You know, that's what you mean. For example, he was bribed to nominate one accused.
The situation is
Potential situation. That's a more, real situation.
yes, it may be contemplated as a criminal nature.
Mr. Chair,
Congressman Tobias.
but there is an encompassing statement that it must be in good faith. So if it is not done in good faith, then he or she is not exempted from criminal and civil criminal liability. Di ba po?
Mr. Chair, I agree. Because the qualifying phrase here is reasonable enough. There is a qualifying for anything done or omitted in the discharge of the task or acts done in good faith within the scope of their official duties. So kung hindi official, hindi good faith, kung evident bad faith or gross negligence, hindi kasama yan. Hindi mo ba?
So yung exemption, so
Nasaan na yung Senate? Bakit iniba mo ng Senate?
okay.
General.
So can we
Put it back. Is it okay to put it back?
Yes, I agree, Mr. Chair.
So can we request a motion from the members of the committee?
Attorney Alcantara.
We defer to the wisdom of the committee, Mr. Chair. But actually, UP Law Center is also the one who inserted acts done in good faith within the scope of their official duties. So that would be acceptable.
Yes, Mr. Chair. So there's enough safeguard since we accepted the phrase acts been done in good faith. So baka naman po pwedeng ma-consider na ibalik na po yung criminal.
Formal motion, Mr. Chair.
Mr. Chair,
Congressman Tobias. Motion.
I cannot make a motion as a member.
Formal motion, Mr. Chair. I move
Mr. Chair,
to,
Mr. Chair, the ombudsman, I think,
I'm sorry.
need to say.
just Mr. Chair, I just wanted to make an observation on this section, Mr. Chair, on the question propounded on the possible crime that may be committed by the commission members. I think just from hindsight, I think a charge of obstruction of justice, destroying the evidence, might be a reasonable scenario that one commissioner or one commission member may commit. And since it's a special law, criminal intent is not necessary. Even if you have good intentions, as long as you have committed it, good faith is not a defense. It's mala prohibitum. So I think that's one example that we could get on that point.
opinion of the ICI on the lawyers.
Yes, Mr. Chair, Your Honors. I think the reason or the wisdom behind this is that the present commission was concerned about possible harassment suits with regard to the investigation that they're conducting. So as not to impede any investigation or probably influence in a way through harassment suits. They are also asking that this be included in the proposed bill or in the act. So with that, as much as possible, the present commission or the ICI would recommend that this be retained. This year.
Mr. Chair, if the reason is harassment during the pendency of the investigation, maybe we can just, gawin na lang natin. For example, for the 3 years, hindi kayo pwedeng criminally charged. But after, mga ibang usapan na yun. What would you think?
Well, kasi medyo yung qualifier lang ako, no? But again po, pwede ba makina explanation again from the ombudsman on the concern of with regard to bad faith or good faith?
Thank you, Mr. Chair. The question provided a while ago was the question provided a while ago to the UP Law Center was, can you think of a crime that may be possibly committed by the commission in the course of its official duties that they might commit, and that good faith might not be a defense, because if it's in good faith, they will be exempted. And I'm just on hindsight, just thought of that scenario, that if an insider or if a commission member would be favoring one other, he might be tempted on destroying the evidence, particular to the transaction or person, and that might fall under the crime of obstruction of justice. And since it's not a mala in se, it's a mala prohibitum, not it's punishable under special law, and then criminal intent or evil intent is not an element or not an intrinsic element. So good faith is not a defense for such commission. So that may fall under that scenario. But we leave it to the criminal law experts of the body to discuss the ramifications, Mr. Chair.
Just a comment ho, no? Hindi ko lang alam kung ito, paano kung baliktarin ho natin yung yung in the sense that kasi ito ho as worded, as proposed by the UP Law Center, nanggal po yung criminal, no? And then to qualify that, linagay po acts done in good faith within the scope of their official duties. Would it be different as far as the interpretation of the ombudsman is concerned if we retain criminal and civil action exemption, but ang qualifying is that in the discharge of the task acts done except for acts done in bad faith and beyond the scope of their official violation of their official duties. Because definitely, pagka meron ko yung sirain na mga ebidensya, hindi lang ko yung official duty yun. In fact, naging medyo sobrang bad faith na ko yun. In that case, why would that be would that answer the interpretation and concern of the ombudsman?
I think we have to decide. I move that we retain the immunity provision to as is. No criminal and civil action shall lie against the commission, etc. So move, Mr. Chair.
Before we say any seconds are taken, Mr. Chair, may I just respond to the comment made by a gentleman from the Ombudsman. Para sa akin po, iba naman yung special criminal laws that do not require criminal intent from the presence or absence of good faith. For example, in obstruction of justice, kasama dun yung forcing a witness not to testify. Huwag ka nang magtestigo para hindi ma-implicate si ganito. Even if you don't have to prove criminal intent for that, obviously that's not an act done in good faith. So we can retain, it's my opinion that we can retain the provision as is. I second the motion.
Congressman Lima.
Yes.
Motion, subject to start.
Yes.
Motion, ma'am.
Meron na po. Meron na po. Move to approve section 8 together with the amendment. Mr. Chair. Mr. Chair. Mr. Chair. Section 9. Section 9.
Yeah, yung section 8.
Section 8 muna.
Okay.
Section 9.
The new section 9, subparagraph, subsection C. I think it has to read line 30. It has to read not being present. Yun ang contempt. When you are not present, that is when you can be cited in contempt.
Refuse to be sworn, sir.
Hindi, ito po. Kasi ang sinasabi dito for the following, based on how it is written out, you will be cited in contempt for being present. You should be cited in contempt for not being present. So, I think yung wording lang po. I think that's how it should be worded, Mr. Chair.
Yes, Mr. Chair. I think the operative word here really is the refusal to answer questions. So we can remove the being present kasi you cannot naman be put on the stand if you're not present.
Paano po kung hindi po nag-appear sa
That's probably covered by section B kong Toby. Yung refuses to comply with the subpoena.
Yes.
For the following, refusal to be sworn in as a witness.
Ayun.
Yes,
Session of investigation.
So accordingly, I formally move, Mr. Chair, with respect to section 9, letter C as appearing in line 30 and 31, that we delete the beginning portion, the following words, being present at a hearing, proceeding, session, or investigation, and begin that subsection C with the words refusal,
Yes.
refusal to be sworn as a witness, etc. So move, Mr. Chair.
Move and seconded.
Section 9.
Section 9, letter C, as amended.
Section 10.
Section 10.
Investigation.
Investigation.
with respect to section 10, Mr. Chair, I noticed that it does not contain any provision on when the ICAIC may conduct an executive session.
Should be,
Wala pa eh.
wala pa.
Yes. May I move that this amendment be included as an additional paragraph to section 10. I'll read it aloud and provide a hard copy to the committee secretary.
Mr. Chair, point of order. Well, hindi pa ko natin yung section 9. Hindi ba sorry. Mr. Chair, I move to approve section 9 with the amendments. So move.
Second.
Mr. Chair.
Second.
Because we moved that, seconded, that's section 9. Line 30, letter C. Section 9, the whole section 9, yes, with amendment.
Section 10 na.
Section 10.
Mr. Chair, may I move that the following paragraph be added as a second paragraph to section 10. I will read this and then submit a hard copy to the committee secretary. The commission may hold executive sessions only under the following circumstances. A, national security concerns when the matters to be discussed involve state secrets or matters of national security. B, privacy and data protection when the matters to be discussed involve personal and sensitive information protected under Republic Act number 10173 or the Data Privacy Act of 2012, and letter C, upon a majority vote. When a majority of all the members of the commission determine through a written and recorded vote that the public interest will be better served by conducting parts of the proceedings in executive session. And then one more paragraph, Mr. Chair. At the beginning of every hearing, the commission must inform all witnesses on the record of their right to request that any part of their testimony be heard in executive session. The request will be resolved by the commission through a majority vote of all its members, taking into account the grounds enumerated in this section.
Second, can we ask remarks from the resource person for the proposal, please? Any comment from
Thank you.
from the persons?
Additional paragraphs.
But of course, to be very clear, that's the additional only
Yeah,
for section 10, because the section 10, the general provision is about the investigation being made in public. And then there's the added provision on executive session. Thank you.
Okay.
Mr. Chair, can we request a motion to prepare a new section 10? There's already a motion, it's already seconded. Now I move that we approve section 10
It's a move,
in all the amendments.
it's a move, says,
So move.
okay. Section, ano? Gabi na. Section 11.
Mr. Chairman, can we ask if there's any comments from the resource person regarding the new section 11?
Section 11, can we ask comment from our resource person, please?
Kung wala po, then Mr. Chair, we extensively discussed this issue yesterday.
Okay, can we, as the civil service,
Yeah, Mr. Chair, as for section 11, I will recommend po that it will be expressed in this section as to who is the appointing authority, that members of the secretariat.
Mr. Chair was still referring to it as numbered section 10, but it is a new section 11, Mr. Chair.
Okay po.
Yung prohibition po for prohibition on the issuance of temporary restraining order, etc. Yun po yung bagong section 11, Mr. Chair. Mr. Chair, I move that we approve section 11.
Second. Second.
Okay, section. Itong
Secretariat. Section 12.
mali kasi yung kan numbering. Ito,
Section 12.
section 12,
Secretariat.
Secretariat. Any comments from our research persons?
Civil service.
Civil
Mr. Chair, I just
Dr. Reorganization.
repeat my comment po earlier that it might be best if the appointing authority of the members of the secretariat would also be included. Because of course, if these are continuing appointments, Mr. Chair, they will be submitted to the CSC for attestation, and the CSC will be looking for the proper appointing authority. And if this is not clarified po, baka it might lead to disapprovals of appointments and causing, it might hamper the operations of the commission po, if it encounters challenges like that, such as disapproved appointments.
Mr. Chair, we hear the opinion of the Executive Director of the ICI.
Your Honor, so we refer to the suggestion of the from the CSC with regard to that, because they're the ones who are the experts on this matter. Thank you.
Mr. Chair, may we know from Executive Director Osaka, who is the appointing authority for those members of the Secretariat and staff of the ICI?
Mr. Chair, Your Honor, considering that under EO 94 that the members of the commission are not considered government employees, and the only government employee would be the executive director, I would be the one currently who would be the appointing authority. Your Honor.
Section
Any more comment from
Section
section 12,
Secretariat.
Secretariat?
There is none anymore.
Mr. Chair, it means that we should put into this that all appointments shall be subject to civil service approval. Is that it?
Yes, Mr. Chair, we can add that particular phrase, but is it the decision of the body that the executive director will be the appointing authority of the members of the secretariat, as well as of the other positions that will be created later on? Because the executive director is to be appointed by the president upon the recommendation of the ICAIC. But it is silent here about the other members of the secretariat, as well as the executive secretary that will, the executive director that will supervise, that will administer the executive secretary, the secretariat. So, appointed by the ICAIC, over the chairman. Chairman na lang po siguro. Yeah.
Yes.
Right? The secretariat to be appointed by the chairman, by the ICAIC, and by the chairman is hereby created to provide administrative, technical, and research. The secretariat the members of which are to be appointed by the chairman.
Sino
Mr. Chair, yes, the members of the secretariat can be appointed by the
Chairman.
commission proper po. And they can delegate that authority to the chairman.
Hindi po ba diretso na lang sa chairman?
Parang administrative task yan eh, di ba?
Yeah,
Ang trabaho nila, commission eh.
appointing authority.
Yung appointment is administrative task.
Oh, either will do.
Spend.
Yeah, pero naman siguro po, Mr. Chair, that it can be,
Para
Meeting suspended for 1 minute.
comparing with the.
Tapos na.
On 12 lines, which is contained in lines 5 up to 13, by adding a sentence designating the commission itself as the appointing authority and authorizing the commission and authorizing the chair to sign the appointments approved by the commission. Subject to style yung language, ang sila ComSec na po ang bahala.
Okay. 1 second. Second.
Motion is approved.
Mr. Chair, can we request a motion to approve the amended section 12?
May I just please invite the attention of the body, especially the secretariat, yung pinatranspose ko po kanina. Meron pa akong pinatranspose about the executive director. So yes, must be included. So I move for the approval of section 12 as amended.
Okay, section 12 is approved. Now we go to section 13. Designation of agency officials and hiring of personnel. Any comments from the members and research persons?
Mr. Chair. Kaya po. In connection with section 13, there is a phrase there that reads second/details such number of lawyers, investigators, auditors, and officials as may be required by the commission to render full-time service to the commission. Yung phrase po na as may be required by the commission may run counter to existing civil service laws because secondment and detail, they are actually covered by a MOA between the two agencies. So it would seem as if with the use of the word as may be required, baka it's unilateral on the part of the commission to require personnel from these other agencies to be seconded or detailed to them.
Ask the Civil Service Commission on how they propose this to be worded, Mr. Chair.
Yeah.
Maybe ask you.
Perhaps, perhaps Mr. Chair, we can add as a last, as a qualifier, being bandang huli, subject to civil service rules and regulations.
Subject to.
Slow and regulations.
I so move, Mr. Chair.
Second.
Section 13. It's been amended.
I would request a motion to approve the amended section 13.
Any motion?
Mr. Chair,
Mr. Chair, I move that section 13. Ano motion ba? Wala pa.
Kayo po.
I move that section 13 in its entirety with the amendments be approved.
Mr. Chair,
Second. Assistant Ombudsman,
thank you, Mr. Chair. It has been observed, Mr. Chair, that COA was deleted, and it is hoped that the Office of the Ombudsman be also deleted in the enumeration. The idea behind the ICAIC, as I understand, is that to assist the Office of the Ombudsman in the investigation because of its limited personnel complement. If the ICAC will also get the personnel of the Office of the Ombudsman, it would not help in any way, Mr. Chair. Thank you very much.
Mr. Chair, I move that we delete the word Office of the Ombudsman on section 13, line 17. So moved, Mr. Chairman.
Because you move line 17, delete the Office of the Ombudsman.
Mr. Chair, may I know the exact text now of section 13 in line pursuant to those amendments? May I just the exact text of section 13 as amended?
Mr. Chair, I think what we just added is after in line 21, first of all, in line 17, we removed the Office of the Ombudsman.
Okay.
And in line 21, we just added after commission the word subject to civil service rules and regulations.
Okay, so we retain as may be required by the commission to render full-time service to the commission as may be subject to civil service rules and regulations.
Yes, Mr. Chair.
Okay, thank you.
Thank you.
Thank you. Mr. Chair, I move to approve section 13 with all amendments. So move.
Second, can we move seconded at section 17? To remove the Office of the Ombudsman and add subject to
service law
civil service law and regulation, rules and regulations. Shall be approved. We now go proceed to section 14,
organizational structure.
Organizational structure and staffing pattern.
Civil service.
Mr. Chair, I move that we approve section 14. So move.
Mr. Chair. Good afternoon, Mr. Chair, Your Honors. Regarding to the section 14 on line 28 po, on the inclusion of technical consultants, if the single is not intended to be a continuous employee of the commission, then we would like to respectfully recommend to delete the same since they will be subject to the procurement process po of delivery of service. Thank you.
So what will be deleted, ma'am?
Okay, Attorney Brand, okay. Okay, go on.
Only the deletion of technical consultants po.
Hindi siya talaga employee.
I move that we delete the words and technical consultants under section 14, line 24.
28, line 28, yeah. Second, any second?
Malabo bata.
Any second?
Second.
It has been moved and seconded that line 28 remove technical consultant.
Mr. Chair, I move that we approve section 14 with amendment. So move.
Second.
Section 15, section 15, kami asaan lang, hindi?
Yung as renumbered, section 15. Just ask, section 15 as renumbered pertaining to support agencies, it now appears to be deleted. Is that correct? Is that the agreement yesterday in the TWG deliberations? As proposed, I understand it is a proposal by AMLAN. I just don't recall if there has been a consensus on the part of those who were present yesterday. Because it pinapagilit lahat eh. This is now the new section 15 as renumbered. So parang inalis na po. Is that it? Ito ba yung intention natin po kahapon?
Mr. Chair, we only have a concern on the second paragraph insofar as it mentions of complete access to information from the AMLC. Because in relation to this, Your Honor, in section, in the earlier section, section 6B,
Hanggang 19 ulit.
there's a proviso under line 1 to 5. It says, provided further that with respect to records or information in the custody of the Anti-Money Laundering Council, any access and disclosure shall be subject to the applicable confidentiality rules and protocols under Republic Act number 9160, otherwise known as the Anti-Money Laundering Act of 2000 as amended, its implementing rules and regulations, public recommendations, and they should be read interagency agreements. So, may I suggest, Your Honor, that the second paragraph of section 15, insofar as the AMLC is concerned, for access to the information from the AMLC is concerned, should be covered by the same limitation under.
Mr. Chair, I think Attorney Trio is talking about the new section 16. The new section 15. What we're talking about is the new section 15, support agency.
Support agencies. Section 15.
Wala pa tayo doon. Wala pa tayo. Sorry.
Mr. Chair, I think my question is now answered by the new section 16.
Yes.
But which will now be section 15. Di ba? Kasi yung support agencies, pwede na talaga itong alisin Kasi nga, dito sa next section, which is the duty to render assistance to the commission, this is all encompassing already. Any officer, employee, etc., when required, shall render assistance to the commission. So, yun po yung sagot doon. So, the new section 15 will actually be this portion on the duty to render assistance to the commission. So, may I therefore move that we approve the new section 15 with the caption duty to render assistance to the commission.
Second.
Okay, so it's been moved and seconded. That section, that the support agencies.
The first paragraph.
And
Meron po kayong concern sa second paragraph?
then you section,
Question, section,
New section.
Section 15. So okay na po. So approve na po yung section 15. Thank you.
your section 15 is.
New section.
So section 16
reads assistant.
assistance from the academic industry and servitization. Is there any comment here? Mr. Chair, I move that we approve section 16 and Toto.
Second. Second.
Yes, it's moved and seconded that section 15, the support agencies is deleted and the new
Section 15.
section 15, duty to render assistance to the commission,
Be approved.
be approved. Section
16 po. Mr. Chair, Congressman Erisi has presented a motion.
Section 16.
Section 16, assistance from the academic industry and civil society, and he moved that it be approved in total, Mr. Chair.
Next second na.
May second na po.
Section 17, lapit na. Mr. Chair, regarding the new section 17, which is the sunset provision, I think we agreed earlier that based on the new life of the commission, it will this wording of 2 years will also be adjusted.
2 years.
3 years.
I know.
June.
December 31.
Fiscal year.
December 31, 2028. Subject to style.
Subject to start, yes.
Be consistent.
Yeah, section 17.
Sunset review is
Section 17, sunset review,
amended.
as amended,
Okay, so
hereby approved.
transitory.
Transitory provision. Lapit na.
Wala pang move. Masyado ka lang ako. Mr. Chair, I move that we approve section 17 with amendment. So moved.
Bawal pala. It has been moved and seconded. Section 17,
Sunset
sunset review.
is amended.
As amended, hereby approved, subject to style.
Mr. Chair, do you know if there's any comments regarding the transitory provisions? If there's none, I would request a member of the committee. Yes, okay.
I think, it's because under section 18, Mr. Chair, it refers to the current ICI, but I think the bill has not referred to, Executive Order 94, formally. So maybe we just need to update, refine, to be able to, refer to the existing ICI under Executive Order 94.
Mr. Chair, just one other point with respect to section 18 transitory provision. I suggest that we specify until when
the existing members of the ICI will hold over, will sit in the holdover capacity. I would suggest not yet a formal motion, but first for discussion, that we make it until the new members appointed by the president have taken their oath and assumed office. If that's okay, I can make the formal motion. Mr. Chair,
Yeah. Director Sana.
Mr. Chair, Your Honors, just a clarification of transitory provision. This talks about or refers to the three members of the present ICI. Would this also include the employees, the ones that have been appointed currently? Because that is also a concern of theirs. Thank you.
Nasa second paragraph yun, ano? The transfer.
Mr. Chair, I move that the following phrase be added at the end of section 18, appearing in line 30, after the word holdover capacity. We add a comma until the new members appointed by the president have taken their oath and assumed office.
Second.
Mr. Chair, meron lang pong nagpapa-clarify. Is there any inconsistency when you say in the first sentence that the current ICI shall be subsumed by the establishment of the new commission to the holdover capacity of the three current commissioners? To me, there's no problem there, but I think the secretariat, certain members of the secretariat wanted it clear. If that is clear to us, clear enough. But when we say subsumed, it does not make conflict. The current ICI, upon the effectivity of this act, the current ICI shall be subsumed by the establishment of the new commission. So if it's subsumed, how come hold over capacity? So kung hold over capacity lang, dapat it shouldn't be subsumed. There must be a better term, a more accurate term than subsumed, or an accurate phrasing than what is now the first sentence of section 18.
Perhaps, Mr. Chair, we can dispense with the first part of section 18 and state it as follows. Upon the effectivity of this act, the current
the three current commissioners,
the current commissioners of the independent the ICI shall continue in holdover capacity, etc. So we delete the portion about subsumed entirely. So Mr. Chair, how about the other staff members that is covered by the second paragraph?
Okay.
The transfer powers are subject to staff. Yes. Agree.
Subject to sign na lang po, i-double check na lang po sa EO94 if commissioners lang talaga nakalagay, is it chairman and commissioners?
Where is it? 94.
Yes, Mr. Chair, with the amendment requested by the request not to specify the EO number.
Yes.
Yes, sir.
No, the chairman, kasi we just have to place the word commissioners, or must it be chairman and commissioners? Para clear, depending on what is written in EO94.
Yes, Mr. Chair, can you recognize the executive director?
it's under section 1 daw po, or under section 1 of EO 94, it refers to chairperson and members. So we use the same terms. Okay.
Is it okay?
So subject to that.
Okay. Yeah, okay. Okay, madam.
Mr. Chair, can we request a motion to approve the amended section 18 transitory provision? Mr. Chair, I move that section 18 appearing in lines 28 to 30 be approved with its amendments.
It has been moved and seconded that
Subject to style.
section 18, line 28 to 30 is approved as amended, subject to style.
Mr. Chair, regarding section 19, dissolution.
Mr. Chair, I move to approve section 18.
19
As amended.
Okay.
Second. Wala pa second.
Second.
Okay na.
Mr. Chair, could we know if there's any comments regarding section 19, dissolution? Yes, Mr. Chair, I have some proposed amendments for section 19. My concern here is the preservation of the evidence and records that are of the deliberations of the new commission. So may I read the proposed amendments? This would be additional paragraphs to section 19, which appears in lines 35 to 40. So after line 40, that the following subsections be included. A, preservation of records. Upon submission of the final report of the ICAIC or upon dissolution of the proceedings, investigation and adjudication of the ICAIC, the ICAIC will designate its secretariat to ensure protection and preservation of all physical and digital records of the investigation. Letter B, storage and access of records. The ICAIC must preserve and store the records with the University of the Philippines Law Center. The ICAIC shall also publish rules and regulations on access of these records after the termination of the investigation. And letter C, penalties for destruction or failure to preserve records. Any party that either destroys or fails to preserve the records of the ICAIC shall be liable for the commission of the offense of removal, concealment, or destruction of documents under Article 226 of the Revised Penal Code, as amended by the penalties under Republic Act 10951, whether or not the offender is a public officer.
Second.
Yeah, please.
Motion ng buong ano.
Please submit, Congressman Jokma, submit to the secretariat.
Buong section 19.
Mr. Chair, I move that we approve section 19 with all the amendments. So moved.
Second.
It's been moved and seconded that section 19, the whole of section 19, as amended, is hereby approved.
Appropriations. Ayan, si Ms.
Section 20.
Mr. Chair, I'm so sorry for the belated reaction. We were just sitting on the thought that it will be deposited or archived with the UP Law Center, as mentioned, as suggested by Congressman Jokno, because as it stands, what is archived with the UP Law Center is through the Office of the National Administrative Register. So these are all administrative documents implementing rules and regulations or internal policies of existing agencies. So I think this will be a very novel, or it will be the first time that such kinds of records will be deposited or archived with the UP Law Center. So you're just thinking if there is a more appropriate or different agency where or office perhaps the Department of Justice?
Mr. Chair, the reason why I proposed the UP Law Center is because I think we can be more assured that no one will, that they will preserve the records in the proper manner, and that they can also request the assistance of the other officers under the UP Law Center, in addition to the National Administrative NA owner. Yes.
Mr. Chair, if I may so add, anyway, it's being provided in the law. And the law does not infringe on any constitutional provision anyway. So I think there's nothing wrong with that. Thank you.
We go to section 20, appropriations.
Mr. Chair, can we get any comment from the Libyan?
DBM.
Good afternoon, Mr. Chair, and other members of this committee. We would like to manifest and for the record the provisions under lines 47 and 48, provided that the approved annual appropriations of the Commission shall be automatically and regularly released by the DBM. So we recognize the importance of this commission. However, of course, we have to harmonize the same with the existing budgeting, accounting and auditing laws, rules, and regulations. And in the release of funds, there are documents that needs to be submitted. Hence, we respectfully recommend the time consideration for the deletion of.
Do you want to just add the phrase subject to existing budgeting and auditing procedures? Nandun naman pala eh. Nandun po pala sa section sa line 44.
Yes, but that is for the initial implementation.
So you want doon sa ano? Because yes.
And the word automatic may be baka ma-misconstrue po as may automatic appropriations po kasi tayo. So baka magkaroon lang po ng confusion on the term automatically released since
So released. Automatically and regularly released.
Shall be automatically and regularly released.
So Senate version.
Mr. Chair, the concern is because the automatic release refers to the available existing appropriations of the GAA. I think what the DBM wants is it to also be applied to succeeding appropriations. Is that correct, Mr. Chair?
Yes, sir, Brian.
Actually, Mr. Chair, the word shall be automatically and regularly released by the DBM is our concern. Since before we release funds, there are procedures and documentary and procedural requirements for the same. So if we will be compelled to, yes, we know that the same is also in the Senate bill and for the kind consideration of the as to the language.
What would you suggest, ma'am?
After the shall be an online 45 shall be included in the annual GAA subject to the kahit ulitin na lang po yung existing budgeting, accounting, and auditing na rules and regulations. And then delete na po yung provided that the annual appropriations of the Commission shall be automatically and regularly released by the DBS.
So Attorney Baraan is, if I may, Mr. Chair, so she's proposing to delete this that the approved annual appropriations of the commission shall be automatically and regularly released by the DBM.
Yes, Mr. Chair.
It would actually soften the entire meaning of the provision. There should be automatic and regular release by the DBM so I'm sorry, Mr. Chair, we need to retain this.
Yes.
Thank you.
Any comment from Attorney Alcantara, UP Law?
Mr. Chair, we will defer to the wisdom of the committee, but we were the ones who actually suggested the inclusion of this proviso.
Yes, and we agree, Mr. Chair.
Yeah.
Mr. Chair, we request
Thank
a
you.
motion from the members to retain and no, Mr. Chair, I move that we approve section 20 and total.
Second. Second.
Okay, as we move seconded, section 20. As amended. We approve in total.
Clarification.
Considering that,
Yes, thank you, Chair. Considering that, assuming that this law will be passed, basically, lumagpas na po yung budget cycle po. So definitely po the budget of the new commission will be taken from the 2026. So just a clarification po, and in that manner, saan ho ba kukunin yung funds as far as the DBM is concerned?
Yes, I think it's stated in section 20, line 43. No. The amount necessary for the initial implementation of this act shall be charged against available appropriations of the current GAA. So I think
Yes, Mr. Chair, considering the also was referring to 2025.
yes.
So moving forward po for 2026.
Mr. Chair, I think we will have a meeting with the Committee on Appropriations on Monday. Yep.
May comments.
from the WH, Attorney Fernandez, do you have any comment? Mike, yes, Mike.
Fiscal autonomy to the commissions and intelligence funds also.
It's still open.
Mr. Chair. Mr. Chair,
From Congressman Tobias.
regarding sections 21, 22, 23, and 24, I think these are regular provisions. Can we request for a omnibus motion to approve sections 21, 22, 23, and 24, Mr. Chair? Mr. Chair, I move that we approve section 21, 22, 23, and 24.
Mr. Chair.
Any comment from UP?
Habol lang, Mr. Chair, it lacks the repealing clause, Mr. Chair, since you have to specify the repeal of the EO. Yes.
Kailangan daw na repealing clause.
Subject to style. Oh, yeah.
Subject to style.
Section 25.
May ano,
Section 24.
may ano si Vice Chairman.
And here to our Vice Chair, Vice Chairman Amante, you are recognized.
Yes, Mr. Chairman, a motion to approve the proposed title. An act creating the Independent Commission Against Infrastructure Corruption, defining its mandate, powers, and functions, and appropriate funds therefore.
Second.
Dito nito. Approval. with thorough scrutiny and discussions of the substitute bill, do I hear a motion to approve the unnumbered substitute bill? Any motion
With the title. New title, sir.
with the new title?
Approve ng bill, sir, with the title. Title pa lang yun.
Title.
Title.
Title lang naman yun eh.
Yung pinaka-bills, buong bill.
Yeah, the wrong bill.
Yeah, the substitute bill.
Mr. Chairman, motion to approve the substitute bill
With the title.
with the title and the committee report.
Yeah, may do I hear a motion?
Subject to style, Mr. Chairman.
Do I hear a motion? Check. The motion has been duly seconded. The numbered substitute bill of House Bill 4453 and 5699 is approved. Do I hear a motion to include all members present as co-authors of the numbered substitute bill, House Bill 4453 and 5699, unless you have especially declined to be an author?
I so move, Mr. Chair, that all members of the committee be made as co-authors or authors of the substitute bill as approved.
It has been moved and seconded to include members or and agreed to be co-authors of the numbers of the bill, except those who want the president not to be included as such. Do I hear a motion to approve in principle the draft committee report on House Bills 4453 and 5699 with a numbered substitute bill?
May picture taking.
Na-approval pa ito, it's been moved.
Sige, sir, wala.
Sandali lang po, wala pa adjourn eh. Wala pang motion to adjourn.
Sige, sir, meron sa.
So move, Mr. Chair.
Second. Teka lang, muna. It has been moved and duly seconded that the draft committee report on House Bills 4453 and 5699, which is a number should be hereby approved.
Okay.
So, do I hear motion to adjourn?
Motion to adjourn.
I move to adjourn. Picture taking.
Sandali lang. After incorporating amendments and enhancement to be fine-tune the numbers to the bill, House Bill 4453 and 5966, Secretariat is hereby instructed to transmit the substitute bill to the Committee on Appropriations for the review of its appropriations, provision, and other provisions with budget implications. Adjourn.